House of Commons Committee of Privileges, matter referred on 21st of April 2022, conduct of Right Honourable Boris Johnson, final report. Membership of the committee: Andy Carter MP, Conservative; Alberto Costa MP, Conservative; Alan Dorrans MP, Scottish National Party; Yvonne Forvog, Labour; Miss Harriet Harman, Labour, Chair; Sir Bernard Jenkin, Conservative; Sir Charles Walker, Conservative. Summary 1. On 21st of April 2022, the House of Commons, without division, referred to the Committee of Privileges a matter concerning the conduct of writ on Boris Johnson MP, the member for Uxbridge and South Ruislip, that is, whether he had misled the House and whether that conduct amounted to a contempt. This inquiry goes to the very heart of our democracy. Misleading the House is not a technical issue, but a matter of great importance. Our democracy is based on people electing members of Parliament, not just to enable a government to be formed and supported, but to scrutinise legislation and hold the executive to account for its actions. Our democracy depends on MPs being able to trust that what ministers tell them in the House of Commons is the truth. If ministers cannot be trusted to tell the truth, the House cannot do its job, and the confidence of the public in our democracy is undermined. When a minister makes an honest mistake and then corrects it, that is democracy working as it should. 3. On 19th of July 2022, the committee resolved how it would conduct its inquiry. On 21 July 2022, the committee published a report setting out its procedure. The committee has at all times followed the law and customs of Parliament. The fundamental procedure is governed by the standing orders and precedent of the House. In its procedural resolution, the committee set out a detailed process designed to be both rigorous in its inquiries and fair to Mr Johnson. Neither the government nor any member has proposed to the House that the procedure should be altered or set out how this would be done. The answers to the opinions of Mr Johnson's legal advisers criticising that procedure, to the extent not previously published by this committee, are set out at Annex 1 to this final report. The criticisms are without merit. 4. All the evidence on which the committee has relied, including that from Mr Johnson, has been given on oath, that is, with a signed statement of truth where the evidence is in writing. The committee has disclosed to Mr Johnson all documents that have been submitted to the inquiry without any redaction. Mr Johnson knows the identities of all witnesses. At his request and as part of a fair procedure, Mr Johnson was given notice to all of the issues that arose from the evidence submitted to the committee, so that he might provide his own written evidence. Mr Johnson availed himself of the opportunity to give written evidence, and in addition gave oral evidence at a hearing on 22nd March 2023. Mr Johnson was subsequently given the opportunity to provide further written evidence, which he did on 22nd May 2023. The provisional conclusions of the committee were delivered to Mr Johnson on 8th June 2023 so that he could respond. There is no matter upon which the committee has reported that Mr Johnson has not had the opportunity to answer or comment upon. 5. In our inquiry, we examined what Mr Johnson said to the House about gatherings in number 10 and whether what he said to the House was correct or not. If a statement was misleading, we considered whether it was a genuine error or was intentional or reckless, and whether the record was corrected comprehensively and in good time. 6. We established that Mr Johnson A. had knowledge of the COVID rules and guidance, B. had knowledge of breaches of the rules and guidance that occurred in number 10, C. misled the House. When he said that guidance was followed completely in number 10, that the rules and guidance were followed at all times, that events in number 10 were within the rules and guidance, and that the rules and guidance had been followed at all times when he was present at gatherings. 2. When he failed to tell the House about his own knowledge of the gatherings, where rules or guidance had been broken. When he said that he relied on repeated assurances that the rules had not been broken. The assurances he received were not accurately represented by him to the House, nor were they appropriate to be cited to the House as an authoritative indication of Number 10's compliance with the COVID restrictions. 4. When he gave the impression that there needed to be an investigation by Sue Gray before he could answer questions when he had personal knowledge that he did not reveal. 5. When he purported to correct the record, but instead continued to mislead the House, and by his continuing denials, this committee. D. Was deliberately disingenuous when he tried to reinterpret his statements to the House to avoid their plain meaning and reframe the clear impression that he intended to give, namely, 1. When he advanced unsustainable interpretations of the rules and guidance to advance the argument that the lack of social distancing at gatherings was permissible within the exceptions which allowed for gatherings, and 2. When he advanced legally impermissible reasons to justify the gatherings. 7. We took written evidence, submitted with statements of truth from witnesses present at the relevant times, to inform us of what Mr. Johnson would have known at the time of his statements to the House. We heard oral evidence under oath from Mr. Johnson, in response to Mr. Johnson's proposed reliance on material that was not supported by a statement of truth. We ourselves obtained further evidence on his behalf. We relied only on first-hand evidence and not on hearsay. We considered evidence supplied by the government, including emails, WhatsApp messages, and photographs. We received a limited number of WhatsApp messages from Mr. Johnson. We paid a visit to Number 10 to inspect for ourselves the locations of the various gatherings to which Mr. Johnson referred to in the House. We considered all of the evidence that we received and came to conclusions about the facts. 8. We took into account facts which are not in dispute because they are matters of public record. For example, A. The words used in the rules and guidance. The words used by Mr. Johnson in answer to questions in the House. Public statements made by Mr. Johnson, for example, in press briefings at Number 10. The dates of gatherings. 9. In respect of factual issues which Mr. Johnson disputed in his written and oral evidence, we gave him notice in our fourth report of the likely issues arising out of the evidence we had received. We looked at each disputed question. We put that dispute to him in the oral hearing. We considered his answers alongside all the other evidence. We came to our conclusions about those facts having regard to the quality and reliability, including the consistency of the evidence that we had received. The most important examples of the facts that were disputed were those relating to the gatherings which Mr. Johnson attended. That is, what he would have known about because he was there, what he saw, what was said, what the gathering was for. The facts relating to the assurances that he received from Jack Doyle and James Slack, who were successively appointed as Downing Street Director of Communications by Mr. Johnson. 11. We established what Mr. Johnson knew about the rules and the guidance from his own public statements. This was important because in his evidence to us, Mr. Johnson asserted that the meaning of the rules and guidance was different from the understanding of the reasonable person and from his previous public statements. Having come to conclusions about the facts, we then compared those conclusions with Mr. Johnson's statements to the House and his evidence to us about those statements. We concluded that he misled the House. We considered the nature and extent of Mr. Johnson's culpability in misleading the House. In coming to the conclusion that Mr. Johnson deliberately misled the House, we considered his repeated and continuing denials of the facts. For example, his refusal to accept that there were insufficient efforts to enforce social distancing at gatherings, where a lack of social distancing is documented in official photographs, and that he neither saw nor heard anything to alert him to the breaches that occurred. The frequency with which he closed his mind to those facts, and to what was so obvious, so that eventually the only conclusion that could be drawn was that he was deliberately closing his mind. The fact that he sought to rewrite the meaning of the rules and guidance to fit his own evidence. For example, his assertion that imperfect social distancing was perfectly acceptable when there were no mitigations in place, rather than cancelling a gathering or holding it online, and his assertion that a leaving gathering or a gathering to boost morale was a lawful reason to hold a gathering. His own after-the-event rationalizations, for example, the nature and extent of the assurances he received, the words used, the purpose of the assurances, who they came from, the warning he received about that from Martin Reynolds, his principal private secretary, and his failure to take advice from others whose advice would have been authoritative. His view about his own fixed penalty notice, that he was baffled as to why he received it, is instructive. We came to the view that some of Mr. Johnson's denials and explanations were so disingenuous that they were by their very nature deliberate attempts to mislead the committee and the House, while others demonstrated deliberation because of the frequency with which he closed his mind to the truth. For those reasons, we conclude that Mr. Johnson's conduct was deliberate and that he has committed a serious contempt of the House. We shared our provisional conclusions with Mr. Johnson on 8th of June 2023, inviting him to make further representations. On 9th of June 2023, before the committee had completed its deliberations and delivered its report to the House, Mr. Johnson made a public statement responding to and criticising the inquiry and the committee's provisional conclusions. This was in breach of the expressed requirements of confidentiality imposed by the committee and the ordinary requirement that committee material is confidential unless and until the committee determines that it should be published. This was done before the committee had come to its final conclusions, at a time when Mr. Johnson knew the committee would not be in a position to respond publicly. Mr. Johnson's conduct in making this statement is in itself a very serious contempt. The question which the House asked the committee is whether the House had been misled by Mr. Johnson and, if so, whether that conduct amounted to contempt. It is for the House to decide whether it agrees with the committee. The House as a whole makes that decision. Motions arising from reports from this committee are debatable and amendable. The committee had provisionally concluded that Mr. Johnson deliberately misled the House and should be sanctioned for it by being suspended for a period that would trigger the provisions of the Recall of MPs Act 2015. In light of Mr. Johnson's conduct in committing a further contempt on 9th of June 2023, the committee now considers that if Mr. Johnson were still a member, he should be suspended from the service of the House for 90 days for repeated contempts and for seeking to undermine the parliamentary process by deliberately misleading the House, deliberately misleading the committee, breaching confidence, impugning the committee, and thereby undermining the democratic process of the House, being complicit in the campaign of abuse and attempted intimidation of the committee. We recommend that he should not be entitled to a former member's pass. Introduction: the establishment of this inquiry. On 21st of April, the House of Commons resolved that, given the issue of fixed penalty notices by the police in relation to events in 10 Downing Street and the Cabinet Office, assertions the member for Uxbridge and South Ruislip has made on the floor of the House about the legality of activities in 10 Downing Street and the Cabinet Office under COVID regulations, including but not limited to the following answers given at Prime Minister's questions 1st of December 2021, that all guidance was followed in number 10. Official report volume 704, 8th of December 2021, that I have been repeatedly assured since these allegations emerged that there was no party and no COVID rules were broken. On 8th of December 2021, that I am sickened myself and furious about that, but I repeat what I have said to him. I have been repeatedly assured that the rules were not broken. And 8th of December 2021, that the guidance was followed and the rules were followed at all times. These appear to amount to misleading the House. The House accordingly ordered that this matter be referred to the Committee of Privileges to consider whether Mr. Johnson's conduct amounted to contempt. Our task in this inquiry has been to decide whether or not Mr. Johnson misled the House of Commons, whether or not he thereby committed a contempt of the House, and if so, what was the nature and extent of his culpability. This is what the House of Commons required us to do by referring the matter to us in the terms of the motion quoted above, which was carried without a vote against. The importance of this inquiry. This inquiry goes to the very heart of our democracy. Misleading the House is not a technical issue, but a matter of great importance. Our democracy is based on people electing members of Parliament, not just to enable the government to be formed and supported, but to scrutinise legislation and hold the executive to account for its actions. The House proceeds on the basis that what it is told by ministers is accurate and truthful. The House expects proactive candour and transparency. Our democracy depends on MPs being able to trust that what ministers tell them in the House of Commons is the truth. If ministers cannot be trusted to tell the truth, the House cannot do its job, and the confidence of the public in our democracy is undermined. The House expects all members to act with integrity, which is why we refer to each other as honourable members. Untruthful or misleading statements from ministers are more damaging even than those from opposition or backbench members, because they frustrate and impede the House in its vital role of scrutinising the government. Whereas in this case, the minister who is alleged to have misled the House is the Prime Minister, the head of the government. The effect of any misleading is exceptionally serious, both for the potential impact on public confidence and because the Prime Minister sets a standard for all other ministers of the Crown in how they account to the House. It is inevitable that ministers make mistakes and inadvertently mislead, and when they do, they are expected to correct the record at the earliest opportunity. This happens routinely. When a minister makes an honest mistake and then corrects it, that is democracy working as it should. There is no basis for any fear that the requirement to be truthful with the House has a chilling effect on the ability of ministers to be candid with the House. The House will also be understanding if a minister declines to answer, for example on matters which relate to national security or market sensitivity, but misleading intentionally or recklessly, refusing to answer legitimate questions or failing to correct misleading statements impedes or frustrates the functioning of the House and is contempt. I'm going to skip the footnotes. The subject on which Mr. Johnson is alleged to have misled the House could not have been more serious. The COVID-19 pandemic was the biggest crisis our country has faced in generations and the greatest peacetime challenge in a century. It disrupted lives, separated friends and families, closed businesses, damaged livelihoods, and most tragically of all, has been associated with the deaths of over 150,000 people in the UK. In response, in the interests of protecting public health, the government and Parliament imposed extensive restrictions on people's freedom. It had not been the purpose of this inquiry to examine the rights or wrongs of the COVID rules and guidance, nor have we sought to repeat the inquiry commissioned by Mr. Johnson from the then Second Permanent Secretary at the Cabinet Office, Sue Gray, into the conduct of individual ministers and officials in Number 10. What the House mandated us to do was to investigate whether Mr. Johnson told the truth to Parliament, to the best of his knowledge, about Number 10's compliance with those rules and guidance. The inquiry has been about what was the truth, which is why it goes to the heart of the trust on which our system of accountability depends. This committee is made up of members of Parliament who have been appointed to this role by the House of Commons. The political balance on the committee reflects it in the House as far as possible. The committee comprises 4 Conservatives and 3 opposition MPs, 2 from Labour, 1 from the Scottish National Party. Having said that, we leave our party interests at the door of the committee room and conduct our work in the interests of the House. That is what we have striven to do throughout this inquiry. The procedures in this inquiry. The House's procedures for dealing with cases of privilege are long established, and we have worked within these procedures. Committees do not have power to hear counsel unless they have been given it by the House. They must proceed in an inquisitorial way. However, as has been done before, given the seriousness of this case, the committee agreed and published a procedure for the investigation, setting out both the way in which evidence would be gathered, and the way in which it would be shared with Mr. Johnson. We discuss this further in paragraphs 217 to 221 below, but we have ensured that our inquiry has been robust, rigorous and fair. The committee has been fair in its procedures, not only because that was right as a matter of principle and what Mr. Johnson was entitled to, but also to command the confidence of Parliament and the public. Before we embarked on the substance of the inquiry, we sought advice from our legal adviser, Right Honourable Sir Ernest Ryder, former Senior President of Tribunals and Lord Justice of Appeal, from Speaker's Counsel, and from the clerks of the House on how we should apply the general principles of fairness, the rules of the House, and the procedural precedents that were available to us. Our guiding principles included being transparent. Pursuant to our commitment to show our workings, we published in July 22nd a report setting out the processes we intended to follow, and have followed this up with further public comments on our procedures where appropriate. We proceeded as rapidly as possible. Some delay was engendered by the length of time it took to persuade the government to supply the unredacted documents and records we requested, so that we could be confident our conclusions were based on solid foundation. Further delay was incurred by our agreeing to request by Mr. Johnson for additional time to respond to our evidence and make his own submissions. We did so in order to ensure that Mr. Johnson was being treated fairly. We proceeded as quickly as we could while ensuring evidence was properly obtained and tested. In bringing forward our report, we note that the committee was instructed to carry out this inquiry by the House on 21st of April 2022 without a vote against. We further note that each of the committee's members were appointed to the committee by the House without division. Each member has done their duty on behalf of the House. Despite this, from the outset of this inquiry, there has been a sustained attempt, seemingly coordinated, to undermine the committee's credibility and, more worryingly, that of those members serving on it. The committee is concerned that if these behaviours go unchallenged, it will be impossible for the House to establish such a committee to conduct sensitive and important inquiries in the future. The House must have a committee to defend its rights and privileges, and it must protect members of the House doing that duty from formal or informal attack by undermining designed to deter and prevent them from doing that duty. We will be making a special report separately to the House dealing with these matters. We note that Mr. Johnson at no point denounced this campaign while it was underway. Giving oral evidence, he expressed respect for the committee and said, when pressed to do so, that he deprecated terms such as witch hunt and kangaroo court, but said the people will judge for themselves whether the committee had been fair. Asked in relation to the committee's inquiry, you would not characterise it as a witch hunt or a kangaroo court? He replied, I will wait to see how you proceed with the evidence that you have. Despite a later communication expressing confidence in the committee, he intimated that he would only accept the committee's conclusions if they were favourable to him, which indeed is demonstrated by his abusive reactions to our warning letter, which we will discuss further below. Finally, we note that our inquiry as mandated by the House has been solely into the conduct of Mr. Johnson. We have not investigated, nor in this report do we comment on, the conduct of any other individuals. This report must not be treated as being critical of anyone other than the subject of the inquiry. The evidence. In our inquiry, we examined what Mr. Johnson said to the House about gatherings in number 10, and whether what he said to the House was correct or not. If his statement was misleading, we considered whether it was a genuine error, was reckless, or was intentional, and whether the record was corrected comprehensively and in good time. We considered evidence supplied by the government, including emails, WhatsApp messages, and photographs. We received a limited number of WhatsApp messages from Mr. Johnson. We took written evidence submitted with statements of truth from witnesses present at the relevant times to inform us of what Mr. Johnson would have known at the time of his statements to the House. We relied only on first-hand evidence and not on hearsay or evidence repeated by others. We paid a visit to number 10 to inspect for ourselves the locations of the various gatherings to which Mr. Johnson referred to in the House. As set out in chapters 2 and 3 of this report, on the basis of information that is in the public domain and evidence that the committee has obtained, and in the context of what Mr. Johnson said to the House of Commons, we established what rules and guidance relating to COVID were in force at the relevant time, Mr. Johnson's knowledge of those rules and guidance, Mr. Johnson's attendance at or knowledge of gatherings that breached the rules or guidance, what Mr. Johnson was told by others, and what assurances he was given by them about compliance with the rules and guidance, and what Mr. Johnson told the House. Mr. Johnson spoke in the House of Commons about the question of COVID compliance in number 10 more than 30 times, most particularly on 1st of December 2021, 8th of December 2021 and 25th of May 2022. He gave oral evidence and oath to the committee on 22nd of March 2023. Speaking in the chamber and to the committee, he variously asserted that rules and guidance were followed in number 10 completely at all times and while he was present at gatherings. The rules and guidance and what Mr. Johnson saw or knew. In this section of our report, we will consider the extent of Mr. Johnson's direct knowledge of particular gatherings in number 10 on the basis of his personal experience, and set this in the context of the COVID rules and guidance in force at the time of each gathering. We also highlight contemporary statements made over this period by Mr. Johnson at press conferences and to the House, which evidence his knowledge of the COVID rules and guidance in force at the time. We've focused on 6 gatherings, those on 20th of May 2020, 19th of June 2020, 13th and 27th of November 2020, 18th of December 2020 and 14th of January 2021. Mr. Johnson attended 5 of these gatherings and was briefly in close proximity to the 6th, that on 18th of December 2020. In the next section of this report, dealing with the assertions Mr. Johnson later gave to the House about compliance with COVID rules and guidance, we consider whether, in the light of what he had seen and known at the time of each gathering, as well as of subsequent developments, including assurances he was given by others, it is credible that Mr. Johnson believed and had given sufficient consideration to the assertions he was making. Over the period from May 2020 to January 2021, the period covering the above events, the rules and guidance imposing restrictions to prevent the spread of COVID varied. Nevertheless, regulations consistently imposed restrictions on gatherings between people from different households, with a limited number of exceptions. These exceptions included whether a gathering was essential for work purposes under regulations in force before 1st of June 2020 or reasonably necessary for work purposes under regulations in force from 1st of June 2020. Between May 2020 and April 2021, workplace guidance specified maintaining social distancing where possible. At the material time, Number 10 Downing Street circulated all staff working in those offices with the rules and guidance that they should follow, including social distancing requirements. Mr. Johnson's knowledge of individual gatherings. Gathering on 20th of May 2020. In May 2020, the rules and guidance in force for the prevention of the spread of COVID included restrictions on gatherings of more than 2 people and stated that only absolutely necessary participants should usually physically attend meetings. Mr Johnson told the House of Commons on 11th of May 2020 that if you must go to work and cannot work from home, you should do so provided that your workplace is COVID secure. We are publishing further guidance on that. He also told the House on 11th of May that people should be limiting contact with others. On Wednesday 20th of May, Mr Johnson attended a gathering in the garden of number 10. The invitation list was extensive, and the planning and communications are evidence that the purpose of the gathering was social. We have evidence that the email invitation for this gathering, which was sent by Mr Johnson's principal private secretary, Martin Reynolds, was sent to 200 odd people, and that it encouraged staff who attended to bring your own booze. Alcohol was provided by staff. Fixed penalty notices were issued to a number of those who attended. We have evidence that some officials and advisors felt this event should not go ahead. Mr Johnson's then Director of Communications, Lee Reynolds, describes the tone of the email invitation and the evidence he gave us as clearly social and in breach of COVID guidance, and says he raised concerns about it with Martin Reynolds. Another official has given evidence to us saying, I heard that there were so many people who were unhappy about the party that they thought they were not going to go, and that they themselves said to another official that they thought it was madness. Mr Kane stated in evidence, I do not recall if I personally had a conversation with the PM about the garden party, but it would have been highly unusual for me not to have raised a potentially serious communications risk with the PM directly. Mr Reynolds, with whom Mr Kane had raised his concerns, stated in evidence, it is possible that he, Reynolds, raised concerns with Mr Johnson. However, he added, that it seems more likely that I believed that any issue had been resolved. If I had spoken to the Prime Minister about the event, I believe I would have flagged the comms risk. Not that the event was against the rules, which I did not believe to be the case. We have evidence that trestle tables were set up for drinks to be laid out. We also have evidence that around 40 people were in attendance at this gathering, and that attendees who were there at the same time as Mr Johnson included Mr Johnson's wife, as well as advisors who were not from number 10 but from other government departments. Lee Kane in his evidence stated that it was clear observing all who attended and the layout of the event that this was purely a social function. Now we note that in response to this evidence, Mr Johnson told us he did not share that view, and that is certainly not what he, Lee Kane, said at the time. In his written evidence, Mr Johnson states that he did not believe that the event broke the rules or guidance in force at the time, noting that the guidance recommended holding meetings outdoors or in well ventilated rooms wherever possible. He was aware that there was food and drink at the gathering, but did not consider that this was incompatible with the rules or guidance. He attended for less than half an hour, from 6:02 till 6:30 p.m. He cannot recall how many people were there, but notes that one of our witnesses states there were only 10 people in the garden when he arrives. He states that, I understood this to be a socially distanced outdoor meeting to boost staff morale and team working after what had been a very difficult period. In my view, an opportunity to thank staff and boost morale was essential for work purposes. No one at the time expressed to me any concerns of whether the event complied with the rules or guidance. Mr Johnson drew attention to his apology to Parliament on 12th of January 2022 when he has said, I believed implicitly that this was a work event, but with hindsight I think I have sent everyone back inside.
I should find some other way to thank them, and I should have recognised that even if it could be said technically to fall inside the guidance, there would be millions and millions of people who simply would not see it that way.
In his written evidence, Mr. Johnson added, "I wish, in respect, that we had given some thought to how these events could be perceived. We should have found a way to make clearer that these were work events. Hindsight is a wonderful thing. But it remains the case that at the time I believed the gathering was consistent with the rules and guidance. For the reasons I have given, I still believe so, at least in relation to the short period during which I attended the event." In his oral evidence, Mr. Johnson told us that he did not see Martin Reynolds' email inviting people to the gathering, which invited people to bring their own alcohol, and that he was not aware of the contents of the email. We note that even if this was the case, Mr. Johnson would have become aware of Mr. Reynolds' email before giving evidence to us, because it was leaked to the media in January 2022 and referred to in Sue Gray's final report in May 2022. Notwithstanding this indication of the social purpose of the gathering, Mr. Johnson continues to maintain it was essential for work purposes. Asked to comment on Lee Kane's statement that he might have had a conversation with Mr. Johnson about the event, Mr. Johnson stated that Mr. Kane had not raised concerns about the gathering with him at the time, and that the concerns Mr. Kane raised with others were about the optics of the event, rather than about the breach of the rules or guidance. Asked about Mr. Reynolds' statement that it was possible he had raised concerns with Mr. Johnson, Mr. Johnson replied, "No, not that I can remember, no." Mr. Johnson confirmed that he had seen a trestle table set up in the garden, but did not remember whether there was alcohol on them. Asked about the issue of fixed penalty notices to people present at the gathering, Mr. Johnson stated, "I want to dispute the idea that it was not an essential gathering or not a gathering that was reasonably necessary for work purposes. I don't know why the FPNs were issued, but it may be that they were issued to people who had not a good reason enough to come in from home to that gathering, or people who had come from elsewhere to that gathering. But my firm impression is, and I think it's certainly still the case that Martin Reynolds believes, that the gathering was within the rules, and indeed within the guidance." Mr. Johnson told us that people who say that that event was purely a social gathering are quite wrong. He reiterated his belief that the gathering was essential for work purposes, stating that its purpose was to thank staff who had been working very hard on COVID. This was a day when the Cabinet Secretary had just stepped down. I think the civil servants needed to feel that the business of government was being carried on, and I needed to feel thanked and motivated for their work. In supplementary written evidence, Mr. Johnson corrected his statement that the Cabinet Secretary had just stepped down. This was incorrect. The Cabinet Secretary, Mark Sedwill, did not resign until 29th of June 2020. However, he and I had discussed his potential resignation around the time of the 20th May 2020 event, which is what I had in mind when answering the question. In summary, Mr. Johnson claims that concerns by number 10 officials about the 20th May 2020 gathering were not raised with him at the time, and in any case related to the optics of the event, rather than whether rules or guidance had actually been or were likely to be breached. He claims that at the time that he attended the event, he considered the gathering was essential for work purposes and did not breach the rules of guidance, and that he continues to believe that, despite the Metropolitan Police having issued fixed penalty notices to some attendees. We conclude that, on the basis of the evidence we have received, some senior number 10 officials were concerned about the social nature of the 20th of May 2020 gathering, and were reluctant for it to go ahead. It is not clear whether those concerns were raised with Mr. Johnson at the time.
The social nature of the gathering was indicated by the high number of people invited, with some attendees from outside number 10, as well as Mr Johnson's wife, who we consider it as obvious cannot be described as an absolutely necessary participant, and the installation in the garden of trestle tables with alcohol available. There is evidence that the number of people in attendance increased during the time that Mr Johnson was at the gathering. We note that for the gathering to have been compliant with the rules, it would have had to be essential for work purposes. We do not consider that a social gathering held purely for the purpose of improving staff morale can be regarded as having been essential for work purposes. Moreover, as we set out in further detail below, we do not believe Mr Johnson would have advised the public that this was the case had he been asked this at the time. Gathering on 19th of June 2020. In June 2020, the rules and guidance in force for the prevention of the spread of COVID included restrictions on indoor gatherings of 2 or more people and maintaining social distancing in the workplace of 2 metres wherever possible, and that only absolutely necessary participants should usually physically attend meetings. On 10th of June 2020, Mr Johnson said at a COVID press conference, "I urge everyone to continue to show restraint and respect the rules which are designed to keep us all safe. So please, to repeat what you've heard so many times before, stay alert, maintain social distancing and keep washing your hands." Just over a week later, on Friday 19th of June 2020, Mr Johnson attended a gathering in the Cabinet Room to celebrate his birthday. A cake and alcohol were provided. Some attendees, including Mr Johnson, received fixed penalty notices in relation to this event. Mr Johnson accepted the FPN. Photographs were taken of the event, which were provided to the committee by the Cabinet Office. These show that the gathering was not socially distanced and that it was attended by at least 17 people other than Mr Johnson, despite internal number 10 guidance stating that as part of their specific mitigations there should be no more than 15 people in the Cabinet Room. We also received evidence that the attendees included individuals who were not work colleagues of Mr Johnson, Mr Johnson's wife and his interior designer. In his written evidence, Mr Johnson addressed the fact that he, together with the current Prime Minister Rishi Sunak, was issued with a fixed penalty notice by the Metropolitan Police in relation to this event. I have accepted the conclusion of the police that my participation in the gathering in the Cabinet Room on my birthday, which I knew nothing about in advance, was unlawful. However, to this day it remains unclear to me, and I believe the Prime Minister may feel the same, how precisely we committed an offence under the regulations. I have never been provided with any rationale by the police, in particular how some individuals that attended did not receive a fixed penalty notice. It never occurred to me then that the event on 19th of June 2020 was not in compliance with the rules or the guidance, nor do I consider it reasonable to conclude that I should have known it at the time. I was in the Cabinet Room for a work meeting and was joined by a small gathering of people, all of whom lived or were working in the building. We had a sandwich lunch together and they wished me happy birthday. I was not told in advance that this would happen. No cake was eaten and no one even sang happy birthday. The primary topic of conversation was the response to COVID-19. In oral evidence, Mr Johnson stated that receiving an FPN for this event boggled my mind because I could not understand why I had got it. Asked in oral evidence why he thought that the gathering was compliant with the COVID rules, Mr Johnson replied, "I thought it was reasonably necessary for work purposes because I was standing at my desk surrounded by officials who had been asked to come and wish me a happy birthday. I had only recently recovered from an illness, COVID, and it seemed to me a perfectly proper thing to do." We were about to have another meeting and they were largely the same officials. When it was put to Mr Johnson that presumably your wife and the contractor, the interior designer, were not attending that meeting, Mr Johnson responded,
It is one of the peculiarities of number 10 that the Prime Minister and his family live in the same building. My understanding of the rules is that the Prime Minister's family is entitled to use every part of that building. We note that Mr Johnson's point does not address the question of whether his family and the interior designer were permitted to attend that specific gathering, which Mr Johnson maintains was necessary for official work purposes, and with that number of officials already in the room. Asked to comment on whether it would have been obvious that the event was in breach of the guidance, in light of 2 photographs received by the committee showing that the gathering was not socially distanced, as well as that fact that it was attended by those whose presence was not absolutely necessary, Mr Johnson replied, "No, it is a matter of how unobvious it was to me that this was any kind of breach that the press office publicised this meeting in the Times. I had absolutely no sense while this event was taking place, and indeed at any time later, that it was in contravention of either the rules or the guidance. No one, before I spoke in the House of Commons, suggested to me that it was. It did not strike me as being anything other than an ordinary, common or garden workplace event." Evidence submitted by Jack Doyle, Mr Johnson's press secretary at the time of this gathering and later Director of Communications, makes clear that at a later stage he was doubtful about the compliance of the gathering of 19th of June 2020 with the COVID rules. In WhatsApp messages with other number 10 officials on 25th of January 2022, he discusses that gathering and states that he was struggling to come up with a way that the gathering was within the rules, and he was not sure it would work to suggest that it was reasonably necessary for work purposes. We conclude that there is evidence that the gathering in the Cabinet Room to celebrate Mr Johnson's birthday on 19th of June 2020 was attended by at least 17 people other than Mr Johnson, including by individuals who were not his work colleagues, and that it was not socially distanced. We note that Mr Johnson did not explain why he believed the event was reasonably necessary for work purposes, other than to say that it took place immediately before a work meeting and that it seemed to me perfectly proper for officials to be asked to come and wish me a happy birthday, which we do not regard as convincing. Mr Johnson was also unable to explain why he considered his wife, an interior designer, absolutely necessary participants in a work-related meeting. His assertion that the Prime Minister's family are entitled to use every part of the building does not constitute an explanation. We note that the Metropolitan Police issued Mr Johnson a fixed penalty notice in connection with this event. Mr Johnson accepts that his attendance was unlawful, but states that he is not clear precisely how he committed an offence. We note that he had the right in law to decline to accept the FPN if he had wished to assert he had committed no offence, but that he chose not to do so. Gathering of 13th of November 2020. In November 2020, the rules and guidance enforced for the prevention of the spread of COVID included restrictions on indoor gatherings of 2 or more people and maintaining social distancing of 2 metres or 1 metre with risk mitigations in the workplace wherever possible. At the COVID press conferences over this period, Mr Johnson regularly repeated the phrase hands, face, space while standing at podiums bearing this phrase. On 9th of November, Mr Johnson said at a COVID press conference that neither mass testing nor progress on vaccines are at the present time a substitute for the national restrictions for social distancing, and all the rest. So it is all the more important to follow the rules. 4 days later, on Friday 13th November 2020, Mr. Johnson attended an impromptu leaving gathering for his Director of Communications, Lee Kane, in the vestibule of the press office. Between 15 and 20 people were present. Mr. Johnson joined the gathering and made a speech. Photographs were taken of the event, which were provided to the committee by the Cabinet Office. One of them shows Mr. Johnson with at least 6 other people standing in close proximity. Fixed penalty notices were issued in relation to this gathering for breaching the rules, but not to Mr. Johnson. Mr. Johnson told us in oral evidence that at the event on 13th of November, we followed the guidance completely. He said that, "I don't accept that people were not making an effort to distance themselves socially from each other." He drew attention to the provision in the guidance that 1 metre distancing should be maintained with mitigations where 2 metre distancing was not possible. In relation to the mitigations, he said, "I knew from my direct personal experience that we were doing a huge amount to stop the spread of COVID within the building. We had sanitisers, windows were kept open. We had people working outdoors wherever they could. We had Zoom meetings, we had restrictions on the number of people in rooms, we had perspex screens between desks, and above all, we had testing." The guidance stated that mitigating actions include using screens or barriers to separate people from each other. When asked whether there were screens or barriers in the photographs of the 13th of November event, Mr. Johnson replied, "There were screens or barriers, I believe, in the adjacent press room, from memory." He continued, "I accept that perfect social distancing is not being observed, i.e. in the photographs. But that does not mean that what we were doing, in my view, is incompatible with the guidance. The guidance specifically allows for workplace freedoms to decide how to implement it, and the operative condition is where possible." Mr. Johnson said that mitigations at the event included the fact that we avoided physical contact. For instance, as the guidance says, we didn't touch each other's pens. We didn't pass stuff to each other if we could possibly avoid it. When it was put to him that presumably people were passing drinks to each other because we've seen the picture, Mr. Johnson replied, "Of course, this is guidance, and I'm not going to pretend that it was enforced rigidly, but that is explicitly what the guidance provides for." When pressed later in the questioning on the fact that no mitigation seemed to be evident in the photographs of the 13th of November event, Mr. Johnson said, "Yes, and that is because that was a space where people congregated fast. If I wanted to get a message out, it was the natural place to do it." The guidance in force at the time stated that where the social distancing guidelines cannot be followed in full, even through redesigning a particular activity, businesses should consider whether that activity needs to continue for the business to operate, and if so, take all the mitigating actions possible to reduce the risk of transmission between their staff. In interpreting the guidance as it stood on November 2020, the following points should therefore be borne in mind. If 2 metre distancing could not be achieved, then 1 metre distancing and mitigations were obligatory for social distancing to said to have been achieved. And social distancing was not considered achieved if 1 metre distancing was maintained without mitigations. Mr. Johnson was correct to state that whether social distancing was being defined as 2 metres or as 1 metre with mitigations, the guidance advised achieving social distancing wherever possible. However, a gathering which was not socially distanced under the above interpretation was nonetheless only compliant with guidance if A. it was not possible to achieve social distancing by redesigning the activity or putting in place mitigations, B. all possible actions to mitigate the risk of the transmission of the virus were being observed, and C. the gathering constituted an activity that needed to continue for the business or organisation to operate. Turning to the rules, Mr Johnson told us that the gathering on 13th of November was absolutely essential for work purposes because 2 senior members of staff, the effective Chief of Staff, Dominic Cummings, and the Director of Communications, Lee Kane, had both left the building or were about to leave the building in pretty acrimonious circumstances, or what were potentially acrimonious circumstances. It was important for me to be there and to give reassurance. He added that it was necessary to steady the ship. It was necessary to show there was no rancour and the business of government was being carried on. This is what we had to do. He said, I understand that people looking at that photograph will think that it looks like a social event. It was not a social event. He later said, I had to accept it, even though it was, I believe, within the guidance and within the rules. Members of the public looking at it will have thought, that looks to me like something he's not allowing us to do. I felt that very keenly in retrospect. I didn't feel it at the time. Writing about events to mark the departure of staff in general, Mr Johnson stated, my view has always been that thanking and encouraging staff and maintaining morale at number 10 was absolutely essential for work purposes. That is especially so in the midst of a crisis as serious as the COVID-19 pandemic. When we gathered occasionally to mark the departure of a colleague, it was my duty as a Prime Minister to say a few words. That is the job of any leader. Mr Johnson was asked, if you had been asked at a press conference with your podium saying hands, face, space, whether it was okay for organisations to hold unsocially distanced farewell gatherings in the workplace, what would you have said? He replied, I would have said that it is up to organisations, as the guidance says, to decide how they are going to implement the guidance. I would have said that the answer is that you should do what the guidance says, and the guidance says that where you put in mitigations, where you do what is possible, where you follow social distancing in a way that reflects the realities of your workspace, that will be in compliance with the guidance. In summary, Mr Johnson has argued that he did not believe the gathering on 13th of November breached the COVID rules or guidance because, in relation to the rules, he considered the gathering essential for work purposes in order to maintain staff morale. And, in relation to the guidance, although he acknowledges that 2 metre social distancing was not being observed, the guidance allowed for a lesser degree of distancing if the activity was critical for the continued operation of the business or organisation and all possible mitigating actions had been taken. There is no doubt that neither 2 metre nor 1 metre distancing was being observed at the gathering. In our inspection of the press office vestibule, we established that the room measures around 5 metres by 6 metres. With between 15 and 20 people present, it would not be possible to maintain social distancing in this space. And the photographs of the event which show Mr Johnson confirm that it was not maintained. We have seen no evidence for Mr Johnson's suggestion that people were making an effort to distance themselves socially from each other, and it does not seem consistent with the photographs seen by the committee. We see no evidence of mitigations being put in place. We consider that Mr Johnson's reference to the existence of screens in the adjacent press office is irrelevant and a distraction, as he knew that there were no screens in the vestibule where the event actually took place. Mr Johnson argued that the gathering was essential for work purposes because of the need to maintain morale in the immediate aftermath of the potentially acrimonious departure of 2 senior members of staff. Even where the legal test of a gathering's reasonable necessity for work purposes was met, the guidance further required that where the social distancing guidelines cannot be followed in full,
businesses should consider whether that activity needs to continue for the business to operate. We note that organisations across the UK were suffering severe staff morale pressures during the COVID pandemic. We do not consider that this in itself provided a licence for Mr Johnson's conveniently flexible interpretation of the rules on gatherings or the guidance on social distancing. We note that Mr Johnson equivocated when asked whether he would have condoned gatherings for this purpose in other organisations. In view of Mr Johnson's repeated exhortations to the public to follow the rules and guidance, indicating the importance he attached to their being taken seriously, we do not believe that, if asked at the time whether unsocially distanced leaving dues to maintain staff morale were permitted under the rules and guidance in force at the time, that he would have advised the British public that they were. We note that the fact that fixed penalty notices were issued for this gathering supports the conclusion that such gatherings were, in fact, not permitted under the rules then in force. We conclude that there is photographic evidence of Mr Johnson's presence at an event on 13th of November 2020, where there was no social distancing, that no mitigations are visible in the photographs, and that the COVID rules and guidance at the time did not allow a socially undistanced event to proceed purely for the purpose of maintaining staff morale, and that this would have been clear to Mr Johnson. Gathering on 27th of November 2020. 2 weeks after the gathering of 13th of November 2020, on Friday 27th of November 2020, Mr Johnson attended and gave a speech at an unplanned leaving gathering to thank a departing special advisor. This again took place in the vestibule to the press office. This is the only one of the 6 events we have focused on in this report, which was not the subject of fixed penalty notices. We have included this event among those focused on because of its significance in terms of its evidential value in considering the nature of gatherings in number 10 and compliance, or otherwise, with relevant guidance. We received 3 witness statements attesting to a lack of social distancing at this event. Jack Doyle, who was press secretary at the time and subsequently director of communications, stated that there were certainly more than 20 people in attendance in a small room measuring about 5 metres by 6 metres. Another witness has stated that they could not make their way from their office through the vestibule because of the throng of people. I stood on tiptoes and thought, how do I get out? I remember vividly that it was about 4 or 5 people deep. I remember thinking, I'd like to get out of my office and I can't. Another witness stated that Mr Johnson joked during this gathering that it was probably the most unsocially distanced gathering in the UK right now. In his written evidence, Mr Johnson stated that he did not remember making the remark about the most unsocially distanced gathering at this particular event, and it seems unlikely given that it was, as number 10 official says, a small and impromptu event. However, he also stated that he might well have made observations in speeches about social distancing. He elaborated in oral evidence, it is certainly likely that I would have drawn attention to the importance of social distancing, since that was very high in people's minds. In his written evidence, he drew attention to the fact that the witness who referred to the alleged remark went on to state that Mr Johnson had a glass of water in his hand, made a short speech, and then went up to his flat. He was the most sensible person there, to be honest. Mr Johnson added that any observations he may have made about social distancing did not mean he thought the guidance was contravened. I did not believe that the guidance required full social distancing at all times, provided you did what you could overall and put additional mitigations in place where social distancing was not possible. Mr Johnson repeated about this event his comments about leaving gatherings in general. I would typically be told by one of my officials that a gathering would shortly be taking place to thank a member of staff who was departing. I would grab a piece of paper and scrawl some things to say about that official's contribution. When I arrived at the room, I would see the same people I worked with every day in the same rooms that they normally worked in. When I looked around the room, I did not think anyone was breaking any rules or guidance. On the contrary, I thought that we were all doing our job. Referring specifically to the gathering on 27th November, Mr. Johnson wrote that he briefly attended the gathering, made a short speech and left after approximately 10 minutes. He added, "I do not believe that anything that I saw in that short period of time that I was at the gathering was contrary to the rules or guidance." In his oral evidence, Mr. Johnson disputed the number of people at the gathering. We received evidence that certainly more than 20 people were present. Mr. Johnson urged us to take account of the conclusions of the Sue Gray report, which referred to 15 to 20 people being present. He also drew attention to a number 10 official's evidence, in which that witness stated that Mr. Johnson's speech at the event was very brief. He spoke for approximately 45 seconds. Then I said something for about 15 seconds. Asked to say whether he accepted the evidence of some witnesses that there was insufficient social distancing at the event, Mr. Johnson replied, "I say that some of them do, some of them don't." We conclude that Mr. Johnson attended an impromptu event in the press office vestibule on 27th November 2020, at which there is evidence from some attendees that social distancing was not observed. One witness stated that there were certainly more than 20 people in attendance. Another stated that Mr. Johnson made a joke about the lack of social distancing. Mr. Johnson draws attention to the second permanent secretary's conclusion that 15 to 20 people were present. There is not a large gap between the two estimates, and clearly no one was taking an exact count of numbers. Even if it were at the lower estimate of 15, that was too many for social distancing of 1 metre, let alone 2 metres, in that space. We note further evidence that there was a large gathering of people in the vestibule, sufficient to make it difficult for a person to make their way through the room. Mr. Johnson stated that he was in attendance for about 10 minutes. This would have afforded him the opportunity to observe a large gathering of people in the relatively small space of the vestibule. We have received no evidence that significant mitigations or efforts to maintain social distancing were in place at the event. We have noted earlier our conclusion that no reasonable reading of the COVID guidance at the time would have considered a socially undistanced event purely for the purpose of maintaining staff morale permissible. Gathering on 18th of December 2020. In December 2020, the rules and guidance in force for the prevention of the spread of COVID included restrictions on indoor gatherings of 2 or more people and maintaining social distancing of 2 metres or 1 metre with risk mitigations in the workplace whenever possible. As we noted above, the previous month on 9th of November, Mr. Johnson said at a COVID press conference that neither mass testing nor progress on vaccines are at the present time a substitute for the national restrictions for social distancing and all the rest, so it is all the more important to follow the rules. On Friday 18th of December 2020, the number 10 press office held a planned drinks event with cheese and wine. It was billed as a Christmas gathering and between 25 and 40 people attended. We received evidence that the gathering began as an end of day catch up, but that the drinks started after that, probably around 5 p.m. That after 6:30 p.m. more people turned up across the house, and that the event ran on into the early hours, 2 a.m. from memory. The gathering was described in evidence we received as beyond desk drinks and far more relaxed than it should have been, with people shoulder to shoulder with each other. One witness described the event as a gathering rather than a party, on the grounds that a party has music and dancing. I don't remember any music being on. One number 10 staff member who did not attend said they later heard that the gathering had escalated and turned into a party. Fixed penalty notices were issued to some of those who attended. Mr. Johnson did not attend this gathering, but he was present in number 10 throughout the day. His official diary records that after chairing a meeting in the Cabinet Room from 8:24 p.m, he went up to his flat at 9:58 p.m. The staircase to the flat begins next to the doorway leading through to the press office. During our site visit to number 10, we established that there is a clear line of view from the foot of the stairs into the press office. There are 3 rooms in a row starting from the staircase. First, small corridor or antechamber, then a vestibule, and then the press office itself. None of these rooms is large. The press office itself is filled with workstations, so the location, which was habitually used for gatherings, was the adjacent vestibule, which can be seen being used for this purpose in the photographs of the gathering on 13th of November 2020. The vestibule is 4 or 5 metres away from the foot of the staircase. In written evidence, Mr. Johnson stated, "I do not recollect seeing or hearing anything that could be described as a party. I do not recollect seeing anyone detectably under the influence of alcohol or hearing anything from my flat. As I have said, I was working and my mind was decisively elsewhere." Referring to claims that there were regular Friday night press office gatherings, Mr. Johnson stated, "I accept that I could see into the press office on my way to the flat, although my attention is often elsewhere when I am returning to the flat. Although I cannot recall any specific occasions, I may well have seen groups of people in the press office when going up to my flat. There would be nothing unusual or untoward about that. They were consistently working late during the COVID-19 pandemic and regularly would meet on Friday evenings to discuss and debrief the events of the week, where wine would be available. I did not ever hear anything from my flat from the press office." When giving oral evidence, Mr. Johnson was asked in relation to the gathering on 18th of December whether he was unaware of the noise or the event taking place. He replied, "Absolutely. If I had looked, what I would have seen, I am sure, was people doing a huge amount of work on a very, very busy evening. Now, I didn't look. I certainly have no memory of seeing any kind of party or illicit gathering going on in the press room on that evening. The first I heard about this, the first I knew about it, was when it was brought to my attention by Jack Doyle almost a year later." We note that Mr. Johnson himself, in private WhatsApp messages sent to his then Press Secretary Jack Doyle on 7th of December 2021 and submitted to us, uses the term party in relation to the gathering on 18th of December 2020. Mr. Johnson's lawyers informed us on his behalf that in these messages Mr. Doyle and the Prime Minister refer to number 10 official talking about the party. However, they only did so as shorthand, because that is what the event is being called in the media. It is not a concession that the Prime Minister believed a party of any kind of illicit or unauthorised gathering had taken place. Mr. Johnson argues that he heard nothing from his flat, nor did he see anyone detectably under the influence of alcohol, but it is not claimed that he did. Mr. Johnson asserts that he did not observe what was going on as he passed the entrance to the press office, because his mind was decisively elsewhere, and my attention is often elsewhere when I am returning to the flat. This may have been the case, but it is in our view not a credible reason why he would not have observed the gathering. Given the evidence we have received that between 25 and 40 people attended the gathering, the drinking began at 5 p.m. and the event was beyond desk drinks and continued till the early hours, and that Mr. Johnson walked past at 9:58 p.m, Given that the issue of fixed penalty notices suggests a social, not work-related nature of the event for at least some time, and the evidence we have suggests that would be a significant proportion of the event, and given that we know from our own evidence that social distancing was not observed, we conclude that Mr. Johnson is unlikely to have been unaware, as he returned to his flat, that a crowded gathering that was in breach of the COVID rules and guidance was taking place in the press office vestibule. We accept, however, that it is possible, although unlikely, that there was nothing untoward occurring in the vestibule at the time he ascended to the flat. Gathering on 14th of January 2021. In January 2021, the rules in force for the prevention of the spread of COVID included restrictions on indoor gatherings of 2 or more people, and guidance stated that there should be social distancing of 2 metres or 1 metre with risk mitigations in the workplace wherever possible, and that only absolutely necessary participants should usually physically attend meetings. At a COVID press conference on 30th of December 2020, Mr. Johnson outlined the Tier 4 restrictions which were in force in London a fortnight later, when the 14th of January gathering took place. He said the restrictions meant not meeting up with friends or family indoors unless they're in the same household or support bubble, and avoiding large gatherings of any kind. On Friday 14th of January 2021, Mr. Johnson attended and gave a speech at a leaving gathering for 2 officials involving 15 people. This was held in the pillared room in number 10. The gathering was described in evidence submitted to the committee by a number 10 official who attended it as not strictly a meeting about work. Photographs submitted to us confirm that Mr. Johnson was in attendance. Fixed penalty notices were issued to staff for this event. In his written evidence, Mr. Johnson told us that he attended the 14th of January 2021 gathering for approximately 10 minutes and made a speech. He told us that his remarks about leaving gatherings in general applied to this event. He added, "I do not believe that anything I saw in the short period of time that I was at the gathering was contrary to the rules or guidance." We note that although Mr. Johnson in his evidence frequently comments on how relatively brief his appearance at gatherings was, the issue is not the duration of his attendance, but whether he was there for long enough to observe the nature of the gathering, the number of other people present, and whether any mitigations were in place if social distancing could not be observed. Mr. Johnson observed that he did not receive a fixed penalty notice in relation to this event, and stated that insofar as others did receive a fixed penalty notice in relation to this event, I can only assume that it related to conduct after my departure, and that the event escalated into something different in nature to what I had seen. Mr. Johnson repeats this assumption more generally in his written submission to the committee, where he states, "I did not know that any of the events that I had attended later escalated beyond what was lawful after I left." An alternative explanation for his not having received an FPN is that an individual person may have had a reasonable excuse for their participation in a gathering that was not, and never was, reasonably necessary for work purposes. Mr. Johnson is aware that some individuals may not have received FPNs in respect of gatherings that nonetheless breached the COVID rules, as he states in his written evidence that he is aware that other attendees at the 19th of June 2020 gathering did not receive FPNs, despite his having received one. The fact Mr. Johnson did not receive an FPN for an individual event, therefore, does not exclude the possibility that he could have made an assessment that the gathering overall was not compliant with the rules. Mr. Johnson also added that no one at the time had raised any concerns with him about whether the event on 14th of January 2021 complied with the rules or guidance, and that no one advised me before or after the event that it was against the rules or guidance to thank departing staff. In his written evidence, he also states more generally that the evidence received by the committee contains not a single document that indicates that I received any warning or advice that any event broke or may have broken the rules or guidance. However, we consider that Mr. Johnson's personal knowledge of the gatherings, in particular what he saw while he was present at them, means that he would not have needed to be reliant on advice to satisfactorily assess their nature. We also note that Mr. Johnson made repeated statements to the House and the public highlighting the responsibility of everyone in the UK to understand and follow the COVID measures in place. For example, on the 13th of May 2020, Mr. Johnson told the House, "We are working together as a country to obey the social distancing rules, which everybody understands. The British people understand that this is a moment for the whole country to come together, obey those rules and apply common sense in their application of them." On 22nd of September 2020, Mr. Johnson said at a COVID press conference, "Never in our history has our collective destiny and our collective health depended so completely on our individual behaviour. If we follow these simple rules together, we will get through this winter together." Again on 22nd of September 2020, Mr. Johnson told the House, after announcing new workplace restrictions and promoting COVID secure business practices, "If people focus on the measures we have outlined today, and particularly on obeying the guidance on social distancing, together we will defeat COVID." In oral evidence, Mr. Johnson disagreed very strongly with the suggestion that a breach of COVID rules would have been obvious to him when he was there. Referring to one of the photographs we invited him to comment on, he said, "There is nothing I can see in that photograph that strikes me as being either against the rules or the guidance." As in relation to other gatherings, Mr. Johnson asserted that, "I thought it was right and proper for me to motivate staff by saying how we were doing and to thank them for what they had done. It wasn't just staff who were leaving who needed to be appreciated. It was the staff who were there who needed to be motivated." Commenting on the array of bottles visible on the table in the photographs, Mr. Johnson said, "I know that there are some bottles on the table. It is customary to say farewell to people in this country with a toast. I did not see any sign of drunkenness or excess. I don't know what happened later on." We note that some participants in the gathering received fixed penalty notices. As we have commented earlier, we do not consider that an event at this time was compliant with COVID rules if the purpose of the event was purely to maintain staff morale. On 18th of May 2023, the government, without prior notice to us, supplied us with new evidence relating to 16 gatherings at Number 10 and at Chequers. Accompanying this was a statement by the government that, as part of their work preparing Boris Johnson's witness statement for the COVID inquiry, due to be filed on 29th of May, the council team supporting Mr. Johnson identified a number of diary entries as potentially problematic. These entries are based on an assessment by Government Legal Department as to events, activities which could reasonably be considered to constitute breaches of COVID regulations. We assessed that this material was potentially relevant to our inquiry and accepted it as formal evidence. The following day, 19th of May, we disclosed the material to Mr. Johnson and requested that he supply us with comments, which we subsequently received. We also asked the Cabinet Office to supply us with further contextual material about the 16 events, including the Prime Minister's diary for each day, and subsequently made a formal order that they should supply us with any agendas or minutes or correspondence that might have a bearing on whether the events were work related. The Cabinet Office has supplied us with this material. From Mr Johnson's lawyers, we received on 22nd of May a statement that none of the events referred to in the documents constitute breaches of COVID regulations, and nobody has ever raised any concerns whatsoever with Mr Johnson about them. Mr Johnson does not accept that any of the events are relevant to the Privileges Committee's investigation. Mr Johnson's lawyers further state each event was lawful for one or more of the following reasons. The gathering was reasonably necessary for work purposes. The gathering took place outside. The rule of 6 applied at the time. The linked household provisions applied. The linked childcare provisions applied, and or emergency assistance and or care or assistance was being provided to a vulnerable pregnant person. We requested that Mr Johnson supply specific justifications for each gathering, and on 2nd of June he made further submissions in response to this request. Mr Johnson has provided, under a statement of truth, explanations of the 16 events referred to in the recent material submitted to us by the government. We have no evidence conflicting with his account. We do not wish to incur the further delay to our inquiry that would result from a detailed investigation of these events, and therefore we treat Mr Johnson's explanations as prima facie true. If for any reasons it subsequently emerges that Mr Johnson's explanations are not true, then he may have committed a further contempt. Arguments advanced by Mr Johnson. Mr Johnson's assertions as to the meaning of the guidance. In his final submission to us, Mr Johnson maintains that the guidance was in fact subject to his flexible interpretation. He states, the committee's interpretation is obviously wrong. The guidance states it in clear and express terms. Objective: ensuring workers maintain social distancing guidelines, 2 metres or 1 metre with risk mitigation where 2 metres is not viable, wherever possible, including while arriving at and departing from work, while in work and when travelling between sites. The committee appears to be suggesting that wherever possible attaches to part of the text in parentheses, but not all of it. That is, with respect, an impossible reading of that sentence. It also entirely ignores the following paragraph, which states, you must maintain social distancing in the workplace wherever possible. The position could not be clearer. The committee also referred on multiple occasions to the part of the guidance that said only absolutely necessary participants should physically attend meetings. The committee appears to present this as an absolute requirement for all meetings, but with respect, that is also incorrect. As pointed out to Sir Bernard, this requirement is part of a list of steps that will usually be needed. Clearly, a step that is usually is needed is not one that must always be followed. The issue is not whether the guidance contemplated that there could be circumstances in which it was not possible to maintain the social distancing guideline of 2 metres or 1 metre with risk mitigation where 2 metres is not viable. The guidance clearly did so. The guidance equally clearly indicated that whether the social distancing guidelines cannot be followed in full, even though redesigning a particular activity, business should consider whether that activity needs to continue for the business to operate, and if so, take all the mitigating actions possible to reduce the risk of transmission to staff. The words "where possible" do not provide a blanket exemption to ignore obligations in the guidance in respect of social distancing. The claim that the word "usually" is in the guidance meant prescriptions could be ignored is similarly misplaced. The guidance relating to meetings as it stood in November 2020 stated 3.4 Meetings. Objective: to reduce transmission due to face-to-face meetings and maintain social distancing in meetings. Steps that will usually be needed. Using remote working tools to avoid in-person meetings. Only absolutely necessary participants should physically attend meetings and should maintain social distancing, 2 meters or 1 meter with risk mitigation where 2 meters are not viable. Avoiding transmission during meetings. For example, avoiding sharing pens, documents and other objects. Providing hand sanitizer in meeting rooms. Holding meetings outdoors or in well ventilated rooms wherever possible. For areas where regular meetings take place, using floor signage to help people maintain social distancing. A reasonable reader of the guidance would note the objective of reducing transmission and consider which of the steps which might usually be needed should apply. For example, if a meeting was held outdoors, the provision about hand sanitizer in meeting rooms would be unnecessary. Mr. Johnson's interpretation is not credible. It suggests that any business could have ignored the guidance by simply deciding mitigations were not possible, and that it was going to disregard most or all of the mitigations which were usually needed. Mr. Johnson's argument that no one raised any concerns with him. Mr. Johnson argues that a proof of his honest belief that rules and guidance were followed in number 10 was that no one raised any concerns with him. He told us in oral evidence that, while he does not remember being specifically assured by any senior civil servant about the rules or the guidance within number 10, the interesting thing is that, to the contrary, nobody gave me any contrary advice. He also said, in all the cases that you mentioned, nobody came to me and said, we've got a problem with this one, you need to worry about this. In response to this argument from silence, we note that one senior official, Mr. Johnson's principal private secretary, Martin Reynolds, did in fact question directly with Mr. Johnson whether the guidance had been followed at all times. See paragraph 147 below, though Mr. Reynolds also maintained in his written evidence that he believed and still believes the events were within the rules. Other number 10 staff, including some of Mr. Johnson's most senior advisers, expressed concerns, albeit not directly to Mr. Johnson, either at the time of the gatherings or when the gatherings came to public attention, that they appeared prima facie breaches of the rules or guidance. Lee Kane told us in evidence that he saw the tone of the email invitation for the gathering of 20th of May 2020 as clearly social and in breach of COVID guidance. We have evidence of WhatsApp messages sent by Jack Doyle in January 2022 stating he was struggling to come up with a way the gathering of 19th of June 2020 was in the rules. A junior official also told us in evidence that they felt it was clear that rules and guidance were not being followed in Downing Street, stating, Number 10, despite setting the rules to the contrary, was slow to enforce any rules in the building. The press office wine time Fridays continued throughout. Social distancing was not enforced. This was all part of a wider culture of not adhering to any rules. Number 10 was like an island oasis of normality. Mr. Johnson also, of course, had personal knowledge of the gatherings, as well as a particular responsibility in his role as Prime Minister to ensure he understood the rules and guidance his government was directing the country to follow, not to rely on others to provide unsolicited advice. Mr. Johnson also argued that if it was obvious to me that these events were contrary to the guidance and the rules, it must have been equally obvious to dozens of others. including the most senior officials in the country. You're not only accusing me of lying, you're accusing all those civil servants, advisors and MPs of lying about what they believed at the time to be going on. The committee is certainly not accusing civil servants or advisors of lying. We note the comments and written evidence we received from a number 10 official that I was following a workplace culture, senior people led it, and that I look back and wouldn't do it now. I did it because senior people did it. We note that it would have been difficult, if not impossible, for many staff members, particularly junior ones, to express concerns about the Prime Minister's behaviour or the behaviour of others in number 10, as this would have been potentially career damaging criticism of senior staff or the head of government. Finally, we note that the issue by the Metropolitan Police of 126 fixed penalty notices to 83 attendees at events in number 10, while not theoretically incompatible with Mr Johnson's argument that no one at number 10 thought they were doing anything wrong, might alternatively be taken to suggest that Mr Johnson was overseeing in number 10 a culture of laxity towards observance of the rules and guidance. Under these circumstances, there was little incentive for officials to confront the Prime Minister with advice that the rules or guidance were being breached. As Prime Minister, Mr Johnson will have played a role, intentionally or otherwise, in the development of this culture. Indeed, he has himself accepted responsibility for what happened in Downing Street. Gatherings. Conclusions. We have set out and analysed evidence in 6 gatherings. This establishes that Mr Johnson had personal knowledge that should have led him, at least after due reflection and as gathering succeeded gathering, to question whether the COVID rules and guidance were being complied with. For several of the number 10 gatherings, as we have detailed, Mr Johnson has argued that it did not occur to him that they were in breach of rules or guidance. This is despite the fact that he must have been aware of the number of people attending, of the absence of official work being done, and of the absence of social distancing without visible mitigations. In each case he argues that he genuinely believed the events were covered by a work-related exemption to the rules. He also argues that efforts to be socially distanced and the putting in place of some mitigations where possible, albeit somewhere other than where the gatherings were taking place, were sufficient for compliance with the guidance. With regards to the rules, the gathering had to be essential or reasonably necessary for work purposes. A workplace thank you, leaving drink, birthday celebration or motivational event is obviously neither essential or reasonably necessary. Mr Johnson is adamant that he believed all of the events which he attended and of which he had direct knowledge were essential. That belief, which he continues to assert, has no reasonable basis in the rules or on the facts. A reasonable person looking at the events and the rules would not have the belief that Mr Johnson had professed. That is plain from the fact that around the UK, during the period of pandemic restrictions, these events did not take place. This point is reinforced by the exposure of the mock Downing Street press conference video, which became public in December 2021. When asked about one of the gatherings we have examined, that of 18th of December 2020, and more generally whether the Prime Minister would condone having a Christmas party, Mr Johnson's then Press Secretary Allegra Stratton was unable to think of any credible response and was evidently embarrassed. 5 of the 6 events we've focused on had the core purpose of thanking staff who had been working hard, or raising morale following the departure of staff. Mr Johnson, when asked whether he would have condoned gatherings for this purpose in other organisations, declined to say that he would. As we concluded in paragraphs 37 and 65 above, in view of Mr. Johnson's repeated exhortations to the public to follow the rules and guidance, indicating the importance he attached to their being taken seriously, we do not believe that, if asked at the time whether unsocially distanced leaving dues to maintain staff morale were permitted under the rules and guidance, he would have advised the British public that they were. We do not believe that. In respect of the sixth event, the gathering to celebrate his birthday on 19th of June 2020, while we have no reason to think that the meeting that followed this event was anything other than a necessary work meeting, Mr. Johnson was unable to provide a convincing reason why this prior gathering was reasonably necessary for work purposes. With regard to the guidance, there was no obvious social distancing at any of the events for which the committee has photographs, and we have direct evidence about the lack of social distancing from witnesses. We have no evidence of substantive mitigations in place in the rooms or areas where the gatherings took place, save the 20th of May 2020 gathering in the garden because it was open air. The mitigations described by Mr. Johnson do not relate to the activities complained of. At best, they are such marginal expedients as not touching pens or passing things to each other, except of course alcohol. Mr. Johnson concedes that social distancing was not possible at these events, but maintains the guidance was complied with completely. That is not correct. Mr. Johnson refers to social distancing of less than 2 meters as imperfect social distancing. This term is not in the guidance. Without all possible efforts being made to redesign the event to allow for social distancing of at least 1 metre with substantive mitigations, that is non-compliance. This inability to maintain full social distancing would have brought into operation the clause in the guidance relating to considering whether in these circumstances the event should take place at all. We conclude that Mr. Johnson's persistence in putting forward this unsustainable interpretation of the guidance is both disingenuous and a retrospective contrivance to mislead the House and this committee. We think it highly unlikely on the basis of probabilities that Mr. Johnson, in the light of his cumulative direct personal experience of the events and his familiarity with the rules and guidance as a most prominent public promoter, could have genuinely believed at the time of his statements to the House that the rules or guidance were being complied with. We think it just as unlikely he could have continued to believe this at the time of his evidence to our committee. We conclude that when he told the House and this committee that the rules and guidance were being complied with, his own knowledge was such that he deliberately misled the House and this committee. What Mr. Johnson was told by others and what he told the House. In the previous section of our report, we considered Mr. Johnson's knowledge of the rules and guidance related to COVID that were in force at the time of the 6 gatherings we are focusing upon, and the extent of his direct personal knowledge of those gatherings. In this section of our report, we consider what Mr. Johnson was subsequently told by other people about compliance at number 10 with the COVID rules and guidance in advance of his assertions to the House about compliance. Mr. Johnson's statements to the House. On the afternoon of 30th of November 2021, the Daily Mirror contacted number 10 to say that they were planning to publish an article alleging that events had taken place in Downing Street in November and December 2020 which had broken COVID rules. It specifically alluded to the gatherings of 27th of November 2020 and 18th of December 2020, which we examine above, among others. The article appeared online later that day and was a paper's front page lead the following day, 1st of December, with the headline, "Boris Party Broke COVID Rules." At Prime Minister's Questions (PMQs) on 1st of December, Mr Johnson was asked by the Leader of the Opposition whether a Christmas party had been held for dozens of people in Number 10 on 18th of December 2020, and he told the House that all guidance was followed completely in Number 10. The Leader of the Opposition followed up his initial question about this gathering with further ones, but Mr Johnson avoided directly answering them. During the week that followed, allegations of gatherings in Number 10 continued to have a high political and media profile. The next Prime Minister's Questions was on 8th of December 2021. The previous evening, ITV had published a video of a mock press conference filmed on 22nd of December 2020, where then Press Secretary Allegra Stratton was asked about the gathering of 18th of December 2020 and appeared embarrassed. At PMQs, before he was asked any specific questions, Mr Johnson stated, "I understand and share the anger up and down the country at seeing Number 10 staff seeming to make light of lockdown measures. I can understand how infuriating it must be to think that the people who have been setting the rules have not been following the rules, because I was also furious to see that clip. I apologise unreservedly for the offence that has caused up and down the country." Mr Johnson went on, "I repeat that I have been repeatedly assured since these allegations emerged that there was no party and that no COVID rules were broken. That is what I have been repeatedly assured." Pressed by the Leader of the Opposition on this issue, Mr Johnson said, "I apologise for the impression that has been given that staff in Downing Street take this lesson seriously. I am sickened myself and furious about it. But I repeat what I have said to him. I have been repeatedly assured that the rules were not broken." Mr Johnson referred to the assurances a further time in response to the next question asked by the Leader of the Opposition, stating, "I have been repeatedly assured that no rules were broken." Later in PMQs, Mr Johnson was asked by Labour MP Catherine West whether there had been a party in Number 10 on 13th of November 2020. We examine an event that took place in Number 10 that evening at paragraphs 49 to 66 above. He replied, "No, but I am sure that whatever happened, the guidance was followed and the rules were followed at all times." In response to a question from Ian Blackford, Mr Johnson commented that the opposition parties are trying to muddy the waters about events or non-events of a year ago. At the same PMQs on 8th of December 2021, Mr Johnson announced that he had commissioned the Cabinet Secretary, Simon Case, to carry out an investigation into the alleged gathering on 18th of December 2020. In written evidence, Mr Johnson argues that by announcing this investigation, he anticipated the possibility that the statement that I made to the House on 1st of December 2020, error for 2021, and the assurances that I had received by others may turn out to be incorrect. Mr Case subsequently recused himself from conducting this investigation, responsibility for which was transferred to the then second Permanent Cabinet Secretary at the Cabinet Office, Sue Gray, with a remit extended to cover other gatherings. On 15th of December 2021, Mr Johnson told the House, "A report is being delivered to me by the Cabinet Secretary into exactly what went on." On 12th of January 2022, Mr Johnson said to the House in relation to the gathering of 20th of May 2020, "All I ask is that Sue Gray be allowed to complete her inquiry into that day and several others so that the full facts can be established." He also urged members to wait for the inquiry to be concluded in response to members' questions about what had happened and the implications for his position as Prime Minister. He further urged members to wait for the inquiry's conclusion in similar terms on 19th of January. At PMQs on 12th of January 2022, after press stories had appeared concerning the gathering in the garden of Number 10 on the 20th of May 2020, Mr Johnson told the House that when he had attended that event, he had believed implicitly that this was a work event. In response to subsequent questioning from the Leader of the Opposition, which was not limited to the gathering of 20th of May but more generally referenced reports of boozy parties in Downing Street during lockdown and the assurances Mr Johnson had given the House, Mr Johnson said, "I accept that we should have done things differently on that evening, 20th of May 2020. As I have said to the House, I believe that the events in question were within the guidance and were within the rules, and that was certainly the assumption on which I operated." On 19th of April 2022, Mr Johnson acknowledged to the House that COVID rules had not been followed at his birthday gathering on 19th of June 2020, for which Mr Johnson and others received fixed penalty notices on the 12th of April 2022. He stated, "It did not occur to me, then or subsequently, the gathering in the Cabinet Room just before a vital meeting on COVID strategy could amount to a breach of the rules. That was my mistake and I apologise for it unreservedly." Following the publication of Sue Gray's report on 25th of May 2022, Mr Johnson made a full statement to the House. That statement maintained that leaving events for number 10 staff, which Mr Johnson had attended, had complied with the rules and guidance at the time when he was in attendance. Mr Johnson said, "I am happy to set on the record now that when I came to this House and said in all sincerity that the rules and guidance had been followed at all times, it was what I believed to be true. It was certainly the case when I was present at gatherings to wish staff farewell. But clearly this was not the case for some of those gatherings after I had left, and at other gatherings when I was not even in the building. So I would like to correct the record, to take this opportunity not in any sense to absolve myself of responsibility, which I take and have always taken, but simply to explain why I spoke as I did in this House." The purported assurances. At an early stage in our inquiry, we asked the Government to supply briefings for PMQs on 1st and 8th of December 2021. The briefing pack for 1st of December 2021 contains no assurances. The Cabinet Office was unable to provide us with the pack for 8th of December. In his written and oral evidence, Mr Johnson addressed the question of who gave him the assurances he referred to in the House on 8th of December 2021 and what those assurances related to. He stated that he had received assurances from Jack Doyle and James Slack, successive number 10 Directors of Communications, and cited evidence provided to the committee by Mr Doyle and Mr Slack to support this. He also cited evidence to the committee from Martin Reynolds, his principal private secretary, who said he believed that reassurances were provided by some of the senior communications staff who were present at the 18th December 2020 event, including Jack Doyle, and from his two parliamentary private secretaries, Sarah Dines MP and Andrew Griffith MP, who both recalled Mr Johnson being given assurances on one occasion by more than one person in the room, Dines, and by multiple different 10 Downing Street staff, Griffith. In his written evidence, Mr Johnson insisted that his statements that he had received assurances were correct and did not mislead the House. He stated that when he had said on 3 occasions that he had repeatedly received assurances, by repeatedly I meant on more than one occasion and by more than one person. In the paragraphs that follow, we consider in turn each of the claims listed above by Mr Johnson and other witnesses that assurances were given. We will examine both the content and the source of the assurances Mr Johnson referred to in the House in order to consider whether it was appropriate for Mr Johnson to refer to those assurances in answer to questions in the House in the way that he did. Assurances from Jack Doyle and James Slack. Jack Doyle was a former Daily Mail journalist who was appointed Mr Johnson's press secretary in early 2020 and served as Director of Communications at Number 10, a role providing political advice rather than a permanent civil service role, from April 2021 February 2022. James Slack was Mr. Doyle's predecessor as Director of Communications, being in that post from January to March 2021, having previously been the Prime Minister's official spokesperson from 2017, serving under both Theresa May and Mr. Johnson, and before that the political editor of the Daily Mail. Both Mr. Slack and Mr. Doyle were personally present at the 18th of December 2020 gathering. Mr. Johnson stated that the initial assurance was given to him by Mr. Doyle following the Daily Mirror's inquiry to number 10 referred to in paragraph 119 above on 30th of November 2021. In oral evidence, Mr. Johnson recalled a conversation with Mr. Doyle on this date. He said, "I talked to Jack Doyle about what had happened at that event, the gathering of 18th of December 2020. This is evening of 30th of November 2021. My diary says it was about 6 o'clock. He comes in and says, as you say, that the Daily Mirror is going to run this story. I asked him about this 18th of December event, and I asked him to describe it. He told me that it was within the rules. He said that people were sitting at their desks, drinking admittedly, but that was not banned, under any of either the rules or the guidance. It was not prohibited. It was regular. It was regular, I'm afraid, for people to drink on Fridays. I concluded that it sounded to me as though the event was within both the rules and the guidance. That fortified me in what I stood up to say the following day." Mr. Johnson indicated that this conversation, together with the press line that was issued to the Daily Mirror that COVID rules were followed at all times, was a basis for his statement in the House on 1st of December 2021 that all guidance was followed completely in number 10 when he was asked by the Leader of the Opposition whether a Christmas party had been held in number 10 on 18th of December 2020. In his written evidence, Mr. Johnson states that he had no basis on which to disbelieve Jack's account of the event, and that it sounded like it was firmly within the work exemption. But we note that Mr. Johnson's evidence does not indicate that he made any efforts to double check Mr. Doyle's account with anyone else or to verify, in particular with any impartial civil servant or legal advisor, his assessment that it was within the rules before relying on it in PMQs the next day. Mr. Doyle corroborates Mr. Johnson's account in his written evidence. He confirmed the description he gave to the Cabinet Office investigation of his conversation with Mr. Johnson on 30th of November 2021. "The only thing I said to the PM was that I didn't regard this as a party and we didn't believe the rules had been broken, and that's what we said at lobby. I said that we have had an inquiry from the Mirror, that it was about a series of events, the redacted thing, December 18th party, and a quiz, and another one I think, and I said that we are saying that this wasn't a party and no rules were broken." He said, what is our line? The line that was sent to the Mirror was, "COVID rules have been followed at all times." Mr. Doyle confirmed that the lines that were drafted for the Mirror became the basis of Mr. Johnson's lines to take in PMQs on 1st of December 2021. It is clear from the evidence that the initial line to take, which became the basis of Mr. Johnson's response to PMQs on 1st of December 2021, was developed quickly by the number 10 media team in response to a press query. Mr. Doyle has stated that this was done under pressure of time and that the press team were not able to mount an investigation into all the events about which the Mirror had made allegations. You're trying to make decisions in an hour and a half, not capable of investigating 4 events that the Mirror were alleging. It is not within our capacity to give and manage a bite-sized assessment of 4 events when approached by the Mirror. WhatsApp messages exchanged between Mr. Doyle and another Downing Street official in the media team on 30th of November 2021 showed the line to take being developed. Mr. Doyle comments, "Key thing is there were never any rules against workplace drinking, so we can say with confidence no rules were broken." It follows that the line to take simply reflected Mr. Doyle's personal belief about Number 10's compliance with COVID rules based on his own experience. Mr. Doyle stated in evidence that conversations which took place between the Prime Minister and me and assurances given were firmly based on my experiences of the prevailing working environment, which has been documented in my answers to the Cabinet Office investigation. Mr. Johnson notes in his written evidence that on the evening of 7th of December 2021, i.e. 1 week after the Daily Mirror's original inquiry and following ITV's release of the mock press conference video, he received a WhatsApp from Jack Doyle advising him on what to say in PMQs the following day, which stated, "I think you can say I've been assured there was no party and no rules were broken." Mr. Johnson also states that he had a conversation with James Slack, where he asked Mr. Slack to describe what happened at the event of 18th of December 2020, during which Mr. Slack confirmed to me, i.e. Mr. Johnson, that the rules were followed. We asked Mr. Slack to confirm for us Mr. Johnson's claim to the Cabinet Office investigation that Mr. Slack and Mr. Johnson had spoken the week after the Daily Mirror's inquiry, and that Mr. Slack had told Mr. Johnson that Number 10 had followed COVID rules. Mr. Slack confirmed that, to the best of my recollection, the account given by Mr. Johnson is correct. He added, "To the best of my recollection, I had one discussion only with Mr. Johnson related to gatherings in Number 10, which is a telephone conversation referenced above. This discussion concerned a gathering on December 18th, 2020, only, and in the terms described by Mr. Johnson, i.e. my belief that the COVID rules were followed at the event. I do not recall any discussion of any other events." Limited scope of assurances from Jack Doyle and James Slack. The evidence we received suggests that the assurances Mr. Doyle and Mr. Slack provided to Mr. Johnson related exclusively to the event on the 18th of December 2020. In relation to the assurances he had referred to in his opening statement to PMQs on 8th of December 2021, Mr. Johnson commented in his written evidence that, as the context of the statement makes clear, the statement related only to the 18th of December 2020 event. As we note above at paragraphs 120 and 123, Mr. Johnson subsequently cited these assurances on 2 further occasions in response to questioning by the Leader of the Opposition. Mr. Johnson states in his final evidence submission of 22nd of May 2023 that the statements made to Parliament on 8th of December 2021 were clearly and expressly limited to assurances that I had received in relation to the 18th of December 2020 event. Mr. Doyle has stated that he did not discuss with Mr. Johnson whether any gatherings had been compliant with COVID guidance as opposed to COVID rules, and did not advise Mr. Johnson to say Number 10 had complied with COVID guidance at all times. Mr. Doyle further stated, "The committee is right to draw a distinction between rules and guidance. Number 10 Downing Street is an old building with limited space. We made every effort to comply with COVID-19 guidelines to the greatest extent that we were able. Where this was not possible, we took measures to mitigate risks, such as installing perspex screens between desks. It is difficult to say that guidelines of this nature were followed at all times, and it would not be possible for me to say that they were." Mr. Johnson's principal private secretary, Martin Reynolds, said that he had queried with Mr. Johnson whether he should say that the guidance had been followed at all times. I do recall asking the then Prime Minister about the line proposed for PMQs on 7th of December, actually 8th of December, suggesting that all rules and guidance had been followed. I cannot remember exactly when I did this, but believe it would have been in the period roughly an hour immediately before PMQs on 7th, 8th of December, when the Prime Minister would have been preparing on his own, as he usually did. He did not welcome the interruption, but told me that he had received assurances at the comms event, the 18th of December 2020 gathering, was within the rules. I accepted this, but questioned whether it was realistic to argue that all guidance had been followed at all times, given the nature of the working environment in number 10. He agreed to delete the reference to guidance. Notwithstanding Mr. Reynolds' statement that Mr. Johnson had agreed to delete the reference to guidance, we know that Mr. Johnson subsequently, on at least 3 occasions, asserted in broad terms that guidance had been followed on 8th of December 2021, 12th of January 2022, and 25th of May 2022. Assurances from others. Mr. Johnson's 2 parliamentary private secretaries, at the time of his statements in the House in December 2021, January 2022, Sarah Dines MP and Andrew Griffith MP, submitted evidence in which they stated that assurances were given to Mr. Johnson by officials. Mr. Griffith explained as PPS he had attended the office meeting, usually held at 9 a.m. in the Cabinet Room on most parliamentary sitting days. Attendees included the Prime Minister, his Chief of Staff and their deputies, the Cabinet Secretary, the Principal Private Secretary, the Director of Communications, the PM's official spokesman, the Political Secretary, and other civil servants and advisers. Mr. Griffith stated it was probable that he had attended the daily office meeting on 1st and 8th of December 2021 and 12th of January 2022, as well as the weekly PMQ's preparation session each Wednesday when Parliament was sitting. Mr. Griffith stated that in the daily office meeting, as newspapers initially published allegations of gatherings in number 10, Mr. Johnson was given assurances by multiple different 10 Downing Street staff present under question 2b(3) above. This was the committee's question: did you at any time give Mr. Johnson any assurances that no parties were held in number 10 during the period of COVID restrictions? This was a daily meeting with a varying cast list of officials and advisers, and I do not recall whom said this or on which precise dates. The substance, though to be clear, not the precise wording, of the assurances by Downing Street to Mr. Johnson in response to the initial articles were: "Are they kidding? We were all working our socks off during COVID. No one had time for any parties." Miss Dines stated, "I remember on one occasion, whilst I was at the meeting room with Mr. Johnson with many other people in the Cabinet Room, that Mr. Johnson asked a question of the meeting. We did follow the rules at all times, didn't we? I recall more than one person in the room said, yes, of course. I am not certain who the people were who said yes, but I am certain they were civil servants, and it was more than one voice. I am about 90% sure one of them was Simon Case, the Cabinet Secretary. I am afraid I cannot recall the date of the meeting, but it was whilst these events were very much in the eye of the media. Whilst I am not sure of the date, I can say with absolute certainty that this happened. I recall thinking, thank goodness, I was reassured. On balance, I think this would have been around the meetings on 1st to 8th of December 2021 and not as late as January 2022. I'm sorry I'm not able to be more specific. In regard to the evidence from Miss Dines and Mr. Griffith, we note that neither witness is able to supply precise dates when assurances were given, not to specify who gave them, except that Miss Dines is about 90% sure that one of them was Simon Case, the Cabinet Secretary. Mr. Case himself has given evidence that he did not give Mr. Johnson assurances in relation to COVID compliance during the gatherings, and does not know whether anyone else gave Mr. Johnson such assurances. In oral evidence, Mr. Johnson said, I don't remember being specifically assured by any senior civil servant about the rules or guidance within number 10. We note that the two PPSs differ as to the content of the assurances they refer to. Miss Dines refers to an assurance that rules were followed at all times, where Mr. Griffith refers to an assurance not about the rules or guidance being followed, but that no parties were held. Mr. Johnson himself was questioned in oral evidence about Miss Dines' evidence. The exchange was as follows. Sir Bernard Jenkin: We have difficulty giving any credibility to the evidence we have received from Sarah Dines, albeit I am sure she gave that evidence in good faith. Have you got anything to say about that? I should give you the opportunity. Johnson: If you're going to question her evidence, I think you need to hear it from her. I can't comment. Jenkin: Okay, if you think it is terribly important that we interrogate Sarah Dines, we will consider that point. Johnson: No, I don't. I think it is probably totally irrelevant. I think the key point is that when I said that I had repeated assurances, I never claimed that one of those people I had giving me those assurances was Simon Case. Mr. Johnson's responses to questions about his statements. In oral evidence, we explored with Mr. Johnson various issues relating to the statements he made to the House about Number 10's compliance with the COVID rules and guidance, and the assurances he claimed to have received from Mr. Doyle and Mr. Slack. Mr. Johnson was asked why he told the House on 1st of December 2021 that all guidance was followed completely in Number 10. He replied that I was misremembering the line that had already been put out to the media about this event, the 18th of December 2020 gathering, which was that COVID rules were followed at all times. But you have to understand that I did not think there was any distinction from the public's point of view between the rules and the guidance. I thought that the public would expect us to follow the guidance as much as the rules. So even though I had said something slightly different, I still believed it was true. When asked why he had not corrected the record when he had realised he had misspoken, Mr. Johnson replied that I didn't think that there was any appreciable difference because it was our job to follow the guidance as much as to follow the rules. Mr. Johnson was asked what further work had been done in Number 10 before PMQs on 8th of December to look into allegations relating to gatherings, given the limited work it had been possible to do in the short time between the initial Daily Mirror inquiry and PMQs on 1st of December, and in particular what he had done to decide whether you needed to correct your previous statement that the guidance had been followed and whether you should reaffirm it. Mr. Johnson replied, When the Allegra Stratton video emerged on the evening of 7th of December, I decided that I was getting conflicting information about what had happened at this gathering on 18th of December. I was troubled by that. I had not been at the thing. I was relying on what I thought were honest and well-intentioned descriptions of this from my trusted advisers, but clearly there was a difference of opinion. So I commissioned a cabinet secretary to conduct an inquiry. Asked why, in response to the question from Catherine West on 8th of December 2021 about the gathering on the 13th of November 2020, Mr. Johnson had said that whatever happened, the guidance was followed and the rules were followed at all times. He replied that in the case of that gathering, as he was there, he knew from his personal experience that the rules and guidance had been complied with. When questioned further on why he had told the House that guidance had been followed at all times, in Number 10, when his principal private secretary, Martin Reynolds, had raised with him before PMQs on that date whether it was realistic to argue that guidance had been followed at all times, Mr. Johnson stated that Mr. Reynolds' advice had been limited to whether or not perfect social distancing was observed, and related only to the assurances Mr. Johnson had received specifically in relation to the gathering on 18th December 2020. Mr. Johnson elaborated. Martin Reynolds was cautious about what I should say in the House. I had received assurances about the rules on 18th of December, but I had not received assurances about the guidance. Martin is not saying that we did not observe the guidance. Martin and I were talking about two different things. I was talking about the totality of following the guidance. He was talking about maintaining perfect social distancing. It was true to say that no one had explicitly reassured me about the guidance. He thought it prudent to take out the reference to the guidance. When we asked Mr. Johnson about the assurances he cited in his opening statement, and in response to questions PMQs on 8th of December 2021, he confirmed that he had not sought assurances as to COVID compliance in number 10 from the Attorney General or any other law officer or government legal advisor. Asked whether the Cabinet Secretary, Simon Case, or any other career, senior, permanent civil servant had given Mr. Johnson these assurances, he replied, "I don't remember being specifically assured by any senior civil servant about the rules of guidance within number 10. He added, "But the interesting thing is that, to the contrary, nobody gave me any contrary advice." Later, being asked about Sarah Dine's statement that she was about 90% sure that Mr. Case had given an assurance at a morning meeting, Mr. Johnson noted that she is not sure, that, frankly, I don't remember Mr. Case doing so, and that I never claimed that one of those people I had given me assurances was Simon Case. Mr. Johnson was asked why he had relied on assurances from Mr. Doyle and Mr. Slack rather than from permanent civil servants or government lawyers. He replied, "The simple answer is that when I needed to discover what had happened and whether the rules were broken, I went first, of course, or I asked first, the senior advisor who was there, and that was Jack Doyle. The following week, you can see that Jack Doyle says in a WhatsApp to me, 'You can say I've been assured there was no party and no rules were broken.' So he says that again to me. I also then rang James Slack. Both Jack and James Slack are people who I have the utmost regard for, and I believed they would be completely straight with me about what had happened, and they both said that the rules had not been broken. The reason I didn't ask a lawyer or another senior civil servant was because they were the people who had been there, and they were the direct. They could give a view about the legality of that event that I didn't think a non-eyewitness would be able to do." Mr. Johnson subsequently wrote to us to state that, "In this exchange, Mr. Costa incorrectly implied that James Slack was a political advisor rather than a permanent civil servant, and I failed to correct that impression. In fact, James Slack was a permanent senior civil servant, as he was the Prime Minister's official spokesperson appointed under Theresa May from 10th of February 2017 until 9th of February 2021. However, he was no longer a civil servant or working within Downing Street in December 2021 when I spoke to him about that event on 18th of December 2020. We note that while the position of Prime Minister's official spokesperson is not a politically appointed role, Mr. Slack had not been a career civil servant prior to his appointment to that role. He was a journalist and had worked as a political editor of the Daily Mail. We also note that Mr. Johnson appointed Mr. Slack to serve as his Director of Communications, a role that is a political appointment, in early 2021. In the oral evidence, Mr. Johnson was asked further why, when the initial assurances had been given to him by Mr. Doyle and Mr. Slack, he did not subsequently discuss the assurances with the Cabinet Secretary, his principal private secretary, or a government lawyer. Mr. Johnson replied that Mr. Reynolds, who had given evidence that he believed the rules had been followed at all times, was a lawyer, and he drew attention to the evidence from Miss Dines and Mr. Griffith that at a morning meeting the view of the assembled civil servants and advisers was that, no, we hadn't broken the rules. Mr. Johnson was asked to name the officials who gave him assurances at the meeting or meetings referred to by Mrs. Dines and Mr. Griffith. The following exchange occurred. Johnson: I cannot name these officials. Costa: Name me one. Johnson: I don't know if I can. I think that. Costa: Why not? Johnson: I think that most of them have indicated they don't want to be named, and Chair: Are you not naming them because you can't remember their names, or because you don't want to breach your anonymity? Johnson: There is at least one adviser that I can think of who has asked not to be named. She would have been in the morning meeting, and I don't want to. Costa: Could you follow that up in writing through your lawyers to the inquiry, confirming the name of the individual that you recall gave you the assurance at the meetings referred to by these two MPs? Johnson: Yes, but if I may say so, Mr. Costa, I don't quite follow the direction of your questions. It is clear from what I have said that I was assured repeatedly by different people and on different occasions that the rules had been followed. Costa: And we are trying to ascertain who these individuals were, so it would be very helpful if you could follow up with the individual you've just referred to. Johnson: OK. Mr. Johnson gave the above understanding to supply further information about an adviser who gave an assurance but did not wish to be named at the oral evidence session on 22nd of March. On 27th of March, Mr. Johnson's lawyers wrote to us as follows. As is clear from the transcript, at Mr. Costa's invitation, Mr. Johnson thought of an official who was in the morning meetings referred to by Andrew Griffith MP and Sarah Downes MP in their evidence to the committee. However, he did not say that he knew precisely who was in each meeting and who specifically gave him the assurances remembered by the MPs. On reflection, Mr. Johnson is still not sure of these matters and does not wish to speculate. Mr. Johnson's lawyers continued. The committee has evidence from Jack Doyle, Andrew Griffith MP and Sarah Downes MP that Mr. Johnson was provided with assurances about the event on 18th of December 2020 by officials at these meetings. Therefore, irrespective of the identities of those officials, there can be no dispute that 1. Assurances were received from Jack Doyle and James Slack. 2. 3 witnesses have given evidence that Mr. Johnson received assurances in at least one of the PMQ prep meetings, and 3. Mr. Johnson was given assurances by more than one person and on more than one occasion. Purported assurances. Conclusions. On 1st of December 2020, Mr. Johnson asserted in the House, based on the assurances he had received in relation to the event on 18th of December 2020, that all guidance was followed completely in number 10. He has subsequently acknowledged that he should have said rules rather than guidance, and said that he did not correct the record because he did not think the public made any distinction between rules and guidance. However, the distinction between rules, which were legally enforceable, and guidance, which was not, but which related to important matters not covered by the rules, such as social distancing, is important, as Mr. Johnson, who had been making almost daily announcements to the nation about the COVID rules and guidance, would have been well aware. This was therefore a significant error. Mr. Johnson had an opportunity to correct it through one of the means available to ministers to correct such errors, but he never did so. Had Mr. Johnson asserted that all rules were followed completely in number 10 in relation to the 18th of December 2020 gathering, that would have been in accord with the line to take developed by the number 10 Director of Communications Jack Doyle the previous evening in response to advance notice of the story about the break in the Daily Mirror. We accept that this line was prepared under pressure of time, and it would probably have been unrealistic in the time available before PMQs on 1st of December for the number 10 staff to make an authoritative assessment of whether the rules and guidance had been complied with at the 18th of December 2020 gathering. It would, however, have been open to Mr. Johnson to tell the House that he had commissioned or planned to commission such an assessment, rather than categorically assert that either the guidance or the rules had been followed completely. Mr. Johnson did not attend this gathering, and therefore claims he was dependent on receiving assurances from others that rules had been complied with. If, as we have concluded, Mr. Johnson was likely to have been aware of the gathering, having personal knowledge of it as he returned to the stairs leading up to his flat a few metres away, then his claim that he was dependent on assurances was misleading and disingenuous to the point of being deliberately misleading. At PMQs on 8th of December 2021, Mr. Johnson asserted in the House, after referring to the video of Number 10 Press Secretary Allegra Stratton talking about the 18th of December 2020 gathering, which appeared on ITV News the previous day, that I repeat that I have been repeatedly assured since these allegations emerged that there was no party and that no COVID rules were broken. That is what I have been repeatedly assured. On two further occasions in this session of PMQs, Mr. Johnson iterated that he had been repeatedly assured that the rules were not broken. Asked whether there had been a party in Number 10 on 13th of November 2020, Mr. Johnson replied, "No, but I am sure that whatever happened, the guidance was followed and the rules were followed at all times." It is not in dispute that Mr. Johnson received assurances in advance of PMQs on 1st of December 2021 from Jack Doyle, Director of Communications at Number 10, and in advance of PMQs on 8th of December 2021 from James Slack, Mr. Doyle's predecessor in the role. In addition to Mr. Johnson's evidence, Mr. Doyle and Mr. Slack, in their evidence, confirmed this. In addition, Sarah Dines MP and Andrew Griffith MP, Mr. Johnson's PPSs at the time, stated in evidence that assurances were given to Mr. Johnson by officials at one of the morning meetings in advance of PMQs. However, neither Miss Dines nor Mr. Griffith can remember the exact date of the meeting or meetings, nor can they specify which individuals gave these assurances, other than that Miss Dines is about 90% sure that one of them was Simon Case, the Cabinet Secretary, and each remembers the content of the assurances differently. Mr. Case himself has given evidence that he did not give an assurance to Mr. Johnson and does not know that anyone else did. Mr. Johnson himself told us that he does not claim Mr. Case gave him an assurance. When asked in oral evidence to identify any official who had given him an assurance at one of the morning meetings, Mr. Johnson was unable to do so, other than to undertake to send the committee details of one advisor that I can think of who has asked me not to be named. His lawyers later wrote to us that, on reflection, Mr. Johnson is still not sure of these matters and does not wish to speculate. On this matter, we conclude that either Mr. Johnson was being deliberately evasive with the committee, or that he has deliberately failed to abide by his undertaking to be candid about an important issue of fact. The only assurances that can therefore be said with certainty to have been given to Mr. Johnson were those from his then Director of Communications, Mr. Doyle, and his previous Director of Communications, James Slack. Both men were concerned chiefly with media handling, and both were at different times political appointees of Mr. Johnson in that role. Mr. Slack had previously been appointed Downing Street Press Secretary by Theresa May, but his overall career arc, having been political editor of the Daily Mail before coming to work for the government, and having moved on subsequently to work as a political correspondent on The Sun, suggests that, as with Mr. Doyle, it would be incorrect to see his role at Number 10 as that of a politically neutral career civil servant, or someone with the necessary competence to judge on matters of COVID compliance. It was understandable, given the timing, that Mr. Johnson's initial comments in the House on 1st of December 2021 were heavily reliant on the advice of his media team at Number 10. However, by the time of the next PMQs on 8th of December, following a period in which he issued gatherings at Number 10 had continued to dominate the news media, he had had a further week to reflect on the answers he had given and to seek more solid, legally based and authoritative assurances, including from government lawyers or permanent career civil servants such as the Cabinet Secretary. In the event, he chose not to do so, but to double down on the answers he had given earlier. Asked why he had not sought advice from government lawyers, Mr. Johnson stated that Jack Doyle and James Slack were the people who had been there, and they were the direct They could give a view about the legality of that event that I didn't think a non-eyewitness would be able to do. In his written evidence, Mr. Johnson likewise argues that it was reasonable for me to find out what had happened from the people who were actually there. Neither Mr. Doyle or Mr. Slack, of course, were professionally qualified to adjudicate on the legality of the proceedings they had witnessed. We have already addressed in paragraphs 103 to 108 above Mr. Johnson's argument that the committee should give significant weight to an absence of evidence that he received advice that rules and guidance were broken in number 10. The overall thrust of Mr. Johnson's evidence to the committee has been to downplay the significance and narrow the scope of the assertions he made to the House. He has argued that a. The assurances he referred to related only to one gathering, that on 18th of December 2020, and were correct in relation to that gathering. His assertions to the House relating to assurances about COVID compliance were only in respect of the rules, not the guidance. And C. When he referred 3 times to having repeatedly been assured about compliance, by repeatedly he meant on more than one occasion and by more than one person. The problem with Mr. Johnson's attempts to portray his assertions to the House as narrow in scope is that this interpretation is directly at odds with the overall impression that members of the House, the media, and the public received at the time from Mr. Johnson's responses at PMQs. The message which Mr. Johnson clearly meant to convey was that rules and guidance at number 10 had been complied with at all times. Indeed, Mr. Johnson initially asserted that guidance had been complied with when he meant to say rules, and rather than correcting what he now admits to have been an error, subsequently reiterated this assertion despite having been advised by his principal private secretary not to make this claim. He was content to convey the impression that the events, plural, against which allegations had been made were in fact non-events, and to paraphrase, that it was nonsense to suggest that the rule makers at the heart of government were also rule breakers. The impression the House would have taken, and we conclude would have been intended to take from Mr. Johnson's repeated references to assurances, was that those assurances had been overarching and comprehensive and to be given great weight. In fact, as we have seen, the only assurances that we can be certain were given to Mr. Johnson were arrived at in haste based on a press line to take, were not subject to investigation before either session of PMQs, and did not emanate from senior permanent civil servants or government lawyers, but from 2 media advisors, and were based only on their personal recollections. Although Mr. Johnson claimed several times to have been given the assurances repeatedly in evidence to us, he scaled down that claim by arguing that by repeatedly he had meant on more than one occasion, so possibly only twice. Mr. Johnson's attempt in his evidence to us to claim that his assertions at PMQs were narrow in scope amounts to ex post facto justification, and was clearly not the message he intended to convey at the time. As an ex post facto justification, it is false. Mr. Johnson's failure to seek adequate assurances has also to be seen in the context of his direct personal experience of non-compliance with COVID rules and guidance at a series of gatherings which he attended or was aware of, as detailed earlier in this report. 4. Misleading the House. The House's resolution of 21st of April 2022 cited some of Mr. Johnson's answers at PMQs on 1st and 8th of December 2021 as appearing to amount to misleading the House, and referred the matter of Mr. Johnson's conduct to us to consider whether it amounted to a contempt. Mr. Johnson himself, in the aftermath of the police issuing of fixed penalty notices and the publication of the Sue Gray report in May 2022, has accepted that the House was misled. He told us in oral evidence, "There was a near universal belief at Number 10 that the rules and guidance were being complied with. That is a general belief that governed what I said in the House. As soon as it was clear that I was wrong, and as soon as the Sue Gray investigation and the Metropolitan Police investigation had concluded, I came to the House of Commons and I corrected the record, as I promised I would." The question we consider in this section of our report is whether the House may have been misled in ways which go beyond those which Mr Johnson has acknowledged. In our fourth report, containing a summary of issues we intend to raise with Mr Johnson in his oral evidence, we set out evidence that the House of Commons may have been misled in the following ways, which the committee will explore. We now revisit that section of the fourth report in the light of the full evidence we have taken in the inquiry. In our opinion, the House was misled in each of the ways we listed. We set out below each category of misleading with a reference to the paragraphs in the present report which deal with it, and some further comments were appropriate. We then consider a number of further instances in which Mr Johnson may have been disingenuous with the House and with us. We also consider the issue of Mr Johnson's correction of or failure to correct the parliamentary record. In paragraph 110 of his written evidence, Mr Johnson states, "I believe that my statement to the House of Commons on 25th of May 2022, the publication of the Sue Gray report and its placing in the library of the House of Commons, constituted a full correction of my honest but inadvertently misleading statements." In paragraph 108, he argues that his statement in the House on 25th of May 2022 was the earliest opportunity at which I could make the necessary correction. When asked during oral evidence on 22nd of March 2023 whether he wished to reassert that guidance had been followed at all times when he was present at gatherings to wish staff farewell, Mr Johnson maintained that "I see no reason to withdraw what I said on 25th of May," and that he did not wish to correct the record. Misleading. Conclusions. Using the categories of misleading set out in paragraph 32 of the fourth report, we conclude that Mr Johnson misled the House when he said on 1st of December 2021 that all guidance was followed completely in Number 10, when he said on 8th of December 2021 that the rules and guidance were followed at all times, on 12th of January 2022 when he said that events at Number 10 were within the rules and guidance, and on 25th of May 2022 when he said that the rules and guidance had been followed at all times when he was present at gatherings to wish staff farewell. Mr Johnson misled the House when he failed to tell the House about his own knowledge of the gatherings where the rules or guidance had been broken. Mr Johnson misled the House when he said on 8th of December 2021 that he relied upon repeated assurances that the rules had not been broken. There is evidence that Mr Johnson was assured by two individuals who had worked at Number 10 at the time that they did not think the gathering of 18th of December 2020 had broken COVID rules. However, we conclude that Mr Johnson had personal knowledge about gatherings which he should have disclosed. Mr Johnson concedes that there was no assurance about any gatherings compliance with the guidance that was in place at the time as opposed to compliance with the COVID rules. Yet Mr Johnson gave the House the impression that those assurances had been overarching and comprehensive in respect of Number 10's compliance with all COVID measures. The purported assurances were only about the gathering of 18th of December 2020, not more generally about Number 10's compliance with the rules and guidance. Yet Mr Johnson gave the House the impression that those assurances had been overarching and comprehensive in respect of Number 10's compliance with COVID measures across a whole period of restrictions. In particular, we have received no evidence that any specific assurance was provided in relation to the gatherings of 20th of May 2020, 19th of June 2020, 13th of November 2020, 27th of November 2020, 14th of January 2021, which we have examined in detail. The context for the initial purported assurance was in response to a media inquiry and the assertion that COVID rules were followed was initially developed in haste and without further investigation as a media line to take. They were therefore not appropriate for Mr. Johnson to cite as an authoritative indication of Number 10's compliance with COVID measures. See paragraphs 137 to 141. The only two purported assurances for which there is firm evidence did not emanate from senior permanent civil servants or government lawyers, but from two media advisers, one of whom was a personal political appointment by Mr. Johnson. The purported assurances consisted only of what those individuals themselves believed about the compliance of the gathering of 18th of December 2020 with the rules. They were therefore not appropriately cited as an authoritative indication of Number 10's compliance with COVID measures. Mr. Johnson misled the House when he gave the impression that there needed to be an investigation by the second permanent secretary to establish whether the rules and guidance had been broken before he could answer questions to the House. While repeatedly making that statement to the House, he had personal knowledge that he did not reveal. We additionally find that Mr. Johnson misled the House when he purported to correct a record on 25th of May 2022. We have concluded above that his statement on that date that the COVID rules and guidance were followed while he was in attendance at farewell gatherings at Number 10 was misleading. As such, it represented a continuation of his previous misleading of the House, and seeking to present it as a correction was itself misleading. His insistence on the truthfulness of his statement in his written evidence and his refusal to correct the record when invited to do so during his oral evidence on 22nd of March 2023 is a further misleading. We further conclude that Mr. Johnson has been disingenuous with the committee in ways which amount to misleading, as follows. By adopting a narrow and restricted interpretation of the assertions he gave to the House in PMQs on 1st and 8th of December 2021, which is at odds with the general impression he clearly wished to give in the House that all the rules and guidance at Number 10 be followed at all times. By claiming that when he referred to having been repeatedly assured by repeatedly, he had meant merely on more than one occasion. We note that this is contrary to common English usage. It's clear when Mr. Johnson used the term repeatedly at PMQs, he wished his audience to suppose that there had been multiple occasions at which assurances had been given, rather than merely more than one, and as suggested by our evidence, possibly as few as two. By undertaking to provide a committee with the name of another person who had provided assurances, and then failing to do so. By stating at the oral evidence session that the committee had withheld from publication the evidence that I rely on, which answers the charges, and a large number of extracts which I rely upon in my defence. But then, when the committee had facilitated the production of that evidence, accompanied by statements of truth, failing to make any use of it in the subsequent final submission. This strongly suggests that Mr. Johnson did not rely on the evidence at all, but was simply using it as a gambit to criticise the committee in the public hearing. By advancing an unsustainable interpretation of guidance in order that he can deny the implications of the evidence, showing a lack of social distancing. By being unable to deny that he said the words, probably the most unsocially distanced gathering in the UK right now, while not admitting that he said them, which has the ring of avoidance about it. Was it a contempt? We have set out above the evidence which leads us to conclude that Mr. Johnson misled the House. The House has instructed us to consider whether Mr. Johnson's conduct in this matter amounted to a contempt. In considering the concept of contempt, we are indebted to a helpful note on the subject by the Clerk of the Journals, which we published as an annex to our second report, and which sets out the relevant background in greater detail than we have scope to do here. Erskine May defines a contempt as follows: any act or omission which obstructs or impedes either House of Parliament in the performance of its functions, or which obstructs or impedes any member or officer of such House in the discharge of their duty, or which has a tendency, directly or indirectly, to produce such results, may be treated as a contempt, even though there is no precedent of the offence. May concludes, it is therefore impossible to list every act which might be considered to amount to a contempt, as parliamentary privilege is a living concept. The House agreed in 1978 that, in general, a House should exercise its penal jurisdiction, one, in any event, as sparingly as possible, and two, only when satisfied that to do so was essential in order to provide reasonable protection for the House, its members, or its officers from impromptu obstruction or attempt at or threat of obstruction causing or likely to cause substantial interference from the performance of their respective functions. As the Clerk of the Journals points out, this means that cases are relatively rare, and while committees have sometimes tried to draw out principles from precedent, they do not consistently do so. Ultimately, in each case, it is up to the Committee of Privileges to determine whether the conduct complained of is a contempt and has reached the necessary bar set by the House, the degree of culpability of the contemptor. We have no difficulty in concluding that Mr. Johnson's misleading of the House has obstructed or impeded the House in the performance of its functions. A core function of the House is scrutiny of the executive. A minister who gives the House false information from the dispatch box is impeding its ability to carry out its essential task, scrutiny. As the Clerk of the Journals notes, misstatements by ministers are inherently likely to obstruct or impede the House. Misstatements by the Prime Minister, at the apex of the governmental system, are even more likely to do so. In the present case, the potential impact on Parliament's ability to scrutinise the executive was of no minor or trivial kind. For the House to be given misleading information about the conduct of ministers and officials at the highest level of government in the midst of the grave national emergency represented by the COVID-19 pandemic, and in relation to how far those ministers and officials were observing the severe restrictions which they were instructing the public at large to follow, it's a matter of great seriousness. We have given very careful consideration to the question of whether Mr. Johnson misled the House, recklessly or intentionally. He himself told us that, "I am here to say to you, hand on heart, that I did not lie to the House. When those statements were made, they were made in good faith and on the basis of what I honestly knew and believed at the time." Mr. Johnson argues that whether or not the COVID rules and guidance were breached at gatherings he attended or was aware of at Number 10, and he continues to maintain in the case of the 6 gatherings we investigated that they were not breached, he himself, along with many others at Number 10, genuinely believed they were complying with the rules and guidance. That's their argument. To a great extent, this defence depends on whether Mr. Johnson genuinely believed that the gatherings were work events that satisfied the criteria in the rules that such events be before June 2020 essential for work purposes, or from June 2020 reasonably necessary for work purposes, and the criteria in the guidance that, if social distancing cannot be observed, such an event needs to continue for the business or organisation to operate. We have noted that Mr. Johnson was not willing to say that. If asked, he would have advised the general public that work events intended solely to raise morale satisfy these criteria. We have set out at paragraph 117 above our conclusion that it is unlikely on the balance of probabilities that Mr. Johnson, in the light of his cumulative direct personal experience of these events, could have genuinely believed the rules or guidance were being complied with. We have also set out in paragraphs 188 to 189 above a list of ways in which we consider Mr. Johnson has misled the House or been disingenuous in his responses to our inquiry. His personal knowledge of breaches of the rules and guidance, combined with his failures proactively to investigate and seek authoritative assurances as to compliance issues, amount to a deliberate closing of his mind, or at least reckless behaviour. We find it highly unlikely that Mr. Johnson, having given any reflection to these matters, could himself have believed that the assertions he made to the House at the time when he was making them, still less that he could continue to believe them to this day. Someone who is repeatedly reckless and continues to deny that which is patent is a person whose conduct is sufficient to demonstrate intent. Many aspects of Mr. Johnson's defence are not credible. Taken together, they form sufficient basis for a conclusion that he intended to mislead. We conclude that in deliberately misleading the House, Mr. Johnson committed a serious contempt. Recommended sanction. It is ultimately for the House, not the Committee of Privileges, to determine whether a contempt has been committed, and if so, what sanction, if any, to impose. To assist the House in this duty, if the House concurs that Mr. Johnson committed a serious contempt, we have considered what sanction would be appropriate. In serious cases, a House has a right to suspend a member, or withhold their salary, or expel them. These sanctions require the explicit approval of the House on the basis of a motion. The House is thus the decision maker in terms of punishment of a member for contempt, just as only the House itself can finally determine whether a contempt has actually been committed. The role of the committee is therefore to carry out a delegated power of investigation and to report its findings to the House, with recommendations for action where appropriate. Motions to implement sanctions recommended by the committee, unlike those recommended by the Committee on Standards or the Independent Expert Panel, are amendable and debatable. The standing orders of the House do not set out a list of sanctions which the committee may recommend. In deciding on its recommendations, the committee will be guided by precedent wherever possible and appropriate. There are a few relevant precedents. Erskine May makes clear that the House may punish acts or omissions for which there is no precedent as long as they fall within the definition of contempt. In addition to sanctions imposed in cases of contempt following Privileges Committee investigations, sanctions may also be imposed in cases considered by the Standards Committee where members are found to have breached the Code of Conduct. In recent years, the Standards Committee has taken steps to codify the use of sanctions in such cases. Breaches of the Code by members may be regarded as being contempts, although they are dealt with under separate procedures set up by the House. As the intertwined history of the Privileges and Standards Committees indicate, there is considerable overlap between contempts and misconduct. It is therefore legitimate for the Privileges Committee, in considering sanctions, to take account of Standards Committee practice when making allowance for differences as well as similarities between standards and privileges. Based on precedent, or by analogy with the Standards Committee's practice, the following options are available to the Privileges Committee in cases of contempt by a member. No further action, requiring an apology in writing, which would normally be published or on the floor of the House by means of a point of order or personal statement. Recommending admonition or reprimand. Recommending withholding of a member's salary or allowances for a specified period, even if the member has not been suspended. Recommending suspension from the House. Recommending suspension from the service of the House for a specified period, during which time the member received no salary and must withdraw from the precincts of the House. Recommending expulsion from the House. We note that suspension from the House for 10 days or longer, following a report from the Committee of Privileges, engages a provision of the Recall of MPs Act 2015, requiring a recall petition to be opened in the member's constituency. There are no precedents for the Committee of Privileges recommending a sanction against a member since this came into force. There are no formal criteria for imposing sanctions in privileges cases. In 2020, the Standards Committee published a list of aggravating and mitigating factors it would take into account in Code of Conduct cases. We have taken them into account. We have concluded above that in deliberately misleading the House, Mr. Johnson committed a serious contempt. The contempt was all the more serious because it was committed by the Prime Minister, the most senior member of government. There is no precedent for a Prime Minister having been found to have deliberately misled the House. He misled the House on an issue of the greatest importance to the House and to the public, and did so repeatedly. He declined our invitation to reconsider his assertions, that what he said to the House was truthful. His defence to the allegation that he misled was an ex post facto justification and no more than an artifice. He misled the committee in the presentation of his evidence. Having taken into account the factors set out above, we considered what sanction would be appropriate in this case. We unanimously concluded that the minimum sanction we should recommend to the House should be suspension from the service of the House, sufficient to engage a provision of the Recall of MPs Act. In agreeing to recommend that sanction, we took into account that this case will set a precedent for the standards of accountability and honesty that the House expects of ministers. We have no doubt that Parliament and the public expect the bar to be set high and for there to be serious consequences if a minister, as in this case, impedes or obstructs the functioning of the House by deliberately misleading it. Having reached this provisional conclusion as to the recommended sanction, we then followed the procedure we had set out in our procedure resolution and communicated to Mr Johnson the committee's proposal to recommend a sanction of suspension for a period long enough to engage the provisions of the Recall of MPs Act, inviting his comments. This material was sent to Mr Johnson under conditions of strict confidentiality. We set out the events that followed and our view of their implications for sanctioning Mr Johnson in the next section of this report. Mr Johnson's resignation as an MP and his attack upon the committee. Mr Johnson's resignation. The procedure adopted by the committee stated that if the committee intends to criticise Mr Johnson or any other individual or body, it will first send a warning letter. And that if an allegation is determined against Mr Johnson, the letter will state the committee's recommendation as to sanction, if any, and invite his submission on the sanction recommended. On 30th of June 2023, we sent by email to Mr Johnson's solicitors the Chair's warning letter and immediately dispatched by hand a single hard copy document containing extracts from the committee's provisionally agreed draft report for inspection by Mr Johnson and his nominated legal advisers under secure and vigilated conditions. Each page of this document was marked as follows: privileged and in strict confidence for the use of Mr Johnson and his nominated legal advisers only. It is a contempt of the House to reveal the contents of this document. There are no other physical copies of the document in existence, and the document is only made available for inspection under invigilated conditions. It must not be copied. The Committee of Privileges will consider final submissions about the content of the document before it publishes its final report to the House. Within 24 hours of receiving our warning letter on Friday 9th of June 2023, Mr Johnson announced his intention to resign as an MP with immediate effect, broke the confidentiality of the process by revealing the contents of the warning letter and linked material, and attacked the committee. In his public statement, Mr Johnson impugned the committee, the integrity of its members, and the impartiality of its staff and advisers, stating, "They have still not produced a shred of evidence that I knowingly or recklessly misled the Commons. They know perfectly well that when I spoke in the Commons I was saying what I believed sincerely to be true and what I had been briefed to say, like any other minister. Their purpose from the very beginning has been to find me guilty, regardless of the facts. This is the very definition of a kangaroo court. The committee's report is riddled with inaccuracies and reeks of prejudice, but under their absurd and unjust process, I have no formal ability to challenge anything they say. The Privileges Committee is there to protect the privileges of Parliament. That is a very important job. They should not be using their powers, which have only been very recently designed, to mount what is plainly a political hit job on someone they oppose. It is in no one's interest that the process the committee has launched should continue for a single day further. I am bewildered and appalled that I can be forced out anti-democratically by a committee chaired and managed by Harriet Harman with such egregious bias. Mr Johnson is wrong to describe the committee and its powers as very recently designed. The powers of the committee and the inquisitorial process that follows are the same as those enjoyed by equivalent committees for many years. It has been commonplace, although not invariable, for the oath to be administered to those appearing in privilege cases, particularly in a case such as this one, which raised very serious issues. The committee and its precursors does not have the power to hear counsel. That would be to adopt a court-like process. In order to ensure fairness to Mr. Johnson, the committee took the additional step of appointing Right Honourable Sir Ernest Ryder, former President of Tribunals and former Lord Justice of Appeal, to advise on the fairness of the process. Sir Ernest had previously carried out a review of fairness and natural justice in the House's standard system. The committee had been advised on these matters by the House's impartial legal and procedural advisers, particularly Speaker's Counsel and the Clerk of the Journals. The committee had had the support of the Independent Clerks team, which has shown unparalleled commitment to the House and our democracy. Given the significance of this inquiry, the committee agreed an explicit resolution of procedure in order to ensure fairness to Mr. Johnson. This stipulated oral evidence would be given on oath and written evidence accompanied by a statement of truth, i.e., the committee would not rely on anything other than evidence that together had expressly affirmed to be true. Mr. Johnson would be furnished with the evidence on which the committee intended to rely. Witnesses could be accompanied by one or more legal advisers. A warning letter would be sent if the report contained criticisms, including an indication on sanction, so that further submissions could be made. In practice, the committee was still more generous to Johnson. Mr. Johnson and his lawyers were provided not just with the evidence on which the committee was proposing to rely, but with all the material the committee received, so that he had the opportunity to seek his own evidence if desired. At Mr. Johnson's request, the committee actively sought evidence accompanied by statements of truth from those Mr. Johnson considered might have evidence which would be helpful to him. Mr. Johnson was given time to make further written submissions. We've taken great care of the publication of the material in this inquiry, since it contains details about many junior civil servants and others which, though disclosed to Mr. Johnson, does not need to be released publicly. Mr. Johnson's incorrect assertion that the committee's powers are new and that procedures are unfair is a continuation of a pattern of statements which are bald expressions of opinion without justification. At the time we wrote to Mr. Johnson, we had come to no final conclusions since we awaited his response. In making his statement when he did, Mr. Johnson knew that the committee would be unable to make a substantive response until it had completed its inquiry, and his assertions would be unchallenged. We note that Mr. Johnson does not merely criticise the fairness of the committee's procedures, he also attacks in very strong, indeed vitriolic terms, the integrity, honesty and honour of its members. He stated that the committee had forced him out anti-democratically. This attack on a committee carrying out its remit from the democratically elected House itself amounts to an attack on our democratic institutions. We consider that these statements are completely unacceptable. In our view, this conduct, together with the egregious breach of confidentiality, is a serious further contempt. We further note that these latest developments cast a new light on some of Mr. Johnson's previous comments and behaviour. We draw attention in paragraph 15 above to the attacks mounted on the committee in the media and by some politicians during the course of the inquiry, couched in terms of personal abuse of the committee's members. In public, Mr. Johnson held himself aloof from these attacks. When we questioned him about the attacks in the oral evidence section, he told us that he deprecated the use of language such as kangaroo courts and witch hunts. A matter of days after the evidence session on 30th March 2023, Mr. Johnson wrote to each individual member of the committee. In his letter, which we print in as Appendix 2 to this report, Mr. Johnson stated, "At the end of the session, Sir Charles and Mr. Costa asked me a series of questions regarding comments that had been made about the committee's work being a witch hunt or a kangaroo court. Having reviewed the transcript, I am concerned that, at the end of what had been a long hearing, I was not emphatic enough in the answers that I provided. As I hope I made clear in those answers, I have the utmost respect for the integrity of the committee and all its members and the work that it is doing." Notwithstanding his protestations of respect for the committee and his earlier deprecation of language such as kangaroo courts and witch hunts, We note that in his statement of 9th of June, Mr Johnson himself used precisely those abusive terms to describe the committee. This leaves us in no doubt that he was insincere in his attempts to distance himself from the campaign of abuse and intimidation of committee members. This, in our view, constitutes a further significant contempt. Nevertheless, on Sunday 11th of June at 6:59 p.m, Mr Johnson's lawyers contacted the clerk of the committee with the following message. I can confirm that Mr Johnson will be responding to the warning letter by 22nd of June 2023 in accordance with paragraph 11 of the resolution on procedure. I would be grateful if you could acknowledge receipt of this message and confirm that the committee will consider Mr Johnson's response in accordance with paragraph 12 of the resolution on procedure before reporting to the House. On 12th of June 2023 at 11:57 p.m, Mr Johnson's lawyers delivered to the committee a further purported response to our warning letter of 8th of June. We have considered its contents, even though we are not obliged to do so. The response was not accompanied by a statement of truth from Mr Johnson. The response makes a series of tendentious accusations. The document is reproduced in full at Annex 3, together with our comments on each paragraph. Before his latest purported submission, we had decided to treat Mr Johnson's public statement, made on 9th of June in response to our warning letter, as his response to that letter and his last submissions to this inquiry. We note that on 9th of June, Mr Johnson stated that it is in no one's interest that the process the committee has launched should continue for a single day further. We agree with Mr Johnson's view on that point. Contrary to Mr Johnson's assertions, he has been given multiple opportunities to set out his views and to comment on the evidence in the inquiry. We set out in detail the evidence and the issues to be raised with him in our fourth report, published on 3rd March 2023. We disclosed to Mr Johnson in unredacted form all the evidence we propose to rely upon and the identity of all our witnesses. At the start of the inquiry in July 2022, Mr Johnson was invited to make an initial submission in writing concerning the allegations and to identify any witnesses that he believed could give relevant evidence. He did not make such a submission or identify any witnesses. Mr Johnson was invited to give oral evidence and publish a written statement, which he did, and was questioned about the evidence and issues raised in the fourth report. Mr Johnson was invited to make final submissions in the inquiry and did so. Mr Johnson was sent details of our proposed criticisms of him and the evidence supporting them on 8th of June 2022 and invited to respond. None of the evidence which we relied on in the material sent to Mr Johnson on 8th of June was new to Mr Johnson. It was the same as that which was put to him in the fourth report and in the oral evidence session. He had the opportunity to respond to that in oral evidence and by written submission, and he did. In his oral evidence, Mr Johnson accused the committee of suppressing evidence which would be helpful to him. We invited him to identify any such evidence. The committee obtained that evidence from the witnesses he had indicated, supported by statements of truth. In the event, he placed no reliance on it. The clear implication is that there was nothing in the evidence, and his criticism in public was a cynical attempt to manipulate member and public opinion. Our final conclusion is in relation to sanction. Although Mr Johnson's resignation as an MP renders it impossible for a sanction of suspension to be imposed, we draw attention to the fact that before the events of Friday 9th of June, we had provisionally agreed to recommend a suspension long enough to engage a provision of the Recall of MPs Act. In the light of Mr Johnson's further contempts, we put on record that if he had not resigned his seat, we would have recommended that he be suspended from the service of the House for 90 days for repeated contempts and for seeking to undermine the parliamentary process by deliberately misleading the House, deliberately misleading the committee, breaching confidence, impugning the committee and thereby undermining the democratic process of the House, being complicit in the campaign of abuse and attempted intimidation of the committee. In view of the fact that Mr Johnson is no longer a member, we recommend that he should not be granted a former member's pass. Conclusions and recommendations. Gathering on 20th May 2020. We conclude that on the basis of the evidence we have received, some senior Number 10 officials were concerned about the social nature of the 20th of May 2020 gathering and were reluctant for it to go ahead. It is not clear whether those concerns were raised by Mr Johnson at the time. The social nature of the gathering was indicated by the high number of people invited, with some attendees from outside Number 10, as well as Mr Johnson's wife, who we consider it as obvious cannot be described as an absolutely necessary participant. And the installation in the garden of trestle tables with alcohol available. There is evidence that the number of people in attendance increased during the time that Mr Johnson was at the gathering. We note that for the gathering to have been compliant with the rules, it would have had to be essential for work purposes. We do not consider that a social gathering held purely for the purpose of improving staff morale can be regarded as having been essential for work purposes. Moreover, as we set out in further detail below, we do not believe Mr Johnson would have advised the public that this was the case had he been asked about this at the time. Gathering on 19th of June 2020. We conclude that there is evidence that a gathering in the Cabinet Room to celebrate Mr Johnson's birthday on 19th of June 2020 was attended by at least 17 people other than Mr Johnson, including by individuals who were not his work colleagues, and that it was not socially distanced. We note that Mr Johnson did not explain why he believed the event was reasonably necessary for work purposes, other than to say that it took place immediately before a work meeting and that it seemed to me perfectly proper for officials to be asked to come and wish me a happy birthday, which we do not regard as convincing. Mr Johnson was also unable to explain why he considered his wife, an interior designer, absolutely necessary participants in a work-related meeting. His assertion that the Prime Minister's family are entitled to use every part of the building does not constitute an explanation. We note that the Metropolitan Police issued Mr Johnson a fixed penalty notice in connection with this event. Mr Johnson accepts that his attendance was unlawful, but states that he is not clear precisely how he committed an offence. We note that he had the right in law to decline to accept the FPN if he had wished to assert he had committed no offence, but that he chose not to do so. Gathering on 13th of November 2020. We note that organisations across the UK were suffering severe staff morale pressures during the COVID pandemic. We do not consider that this in itself provided a licence for Mr Johnson's conveniently flexible interpretation of the rules on gatherings or the guidance on social distancing. We note that Mr Johnson equivocated when asked whether he would have condoned gatherings for this purpose in other organisations. In view of Mr Johnson's repeated exhortations to the public to follow the rules and guidance, indicating the importance he attached to their being taken seriously, we do not believe that, if asked at the time whether unsocially distanced leaving dues to maintain staff morale were permitted under the rules and guidance in force at the time, he would have advised the British public that they were. We note that the fact that fixed penalty notices were issued for this gathering supports the conclusion that such gatherings were, in fact, not permitted under the rules then in force. We conclude that there is photographic evidence of Mr Johnson's presence at an event on 13th of November 2020, where there was no social distancing, that no mitigations are visible in the photographs, and that the COVID rules and guidance at the time did not allow a socially undistanced event to proceed purely for the purpose of maintaining staff morale, and it just would have been clear to Mr Johnson. Gathering on 27th of November 2020. We conclude that Mr Johnson attended an impromptu event in the Press Office vestibule on 27th of November 2020, at which there is evidence from some attendees that social distancing was not observed. One witness stated that there were certainly more than 20 people in attendance. Another stated that Mr Johnson made a joke about the lack of social distancing. Mr Johnson draws attention to the second permanent secretary's conclusion that 15 to 20 people were present. There's not a large gap between the two estimates, and clearly no one was taking exact count of the numbers. Even if it were at the lower estimate of 15, that was too many for social distancing of 1 metre, let alone 2 metres in that space. We note further evidence that there was a large gathering of people in the vestibule, sufficient to make it difficult for a person to make their way through the room. Mr. Johnson stated that he was in attendance for about 10 minutes. This would have afforded him opportunity to observe a large gathering of people in a relatively small space of the vestibule. We have received no evidence that significant mitigations or efforts to maintain social distancing were in place at the event. We have noticed earlier our conclusion that no reasonable reading of the COVID guidance at the time would have considered a socially undistanced event purely for the purpose of maintaining staff morale permissible. Gathering on 18th of December 2020. Mr. Johnson argues that he heard nothing from his flat, nor did he see anyone detectably under the influence of alcohol, but it is not claimed that he did. Mr. Johnson asserts that he did not observe what was going on as he passed the entrance to the press office because his mind was decisively elsewhere, and my attention is often elsewhere when I am returning to the flat. This may have been the case, but it is in our view not a credible reason why he would not have observed the gathering. Given the evidence we have received that between 25 and 40 people attended the gathering, that drinking began at 5 p.m. and the event was beyond desk drinks and continued till the early hours, and that Mr. Johnson walked past at 9:58 p.m., given that the issue of fixed penalty notices suggests a social, not work-related nature of the event, for at least some time, and the evidence we have suggests it would be a significant proportion of the event. And given that we know from our own evidence that social distancing was not observed, we conclude that Mr. Johnson is unlikely to have been unaware, as he returned to his flat, that a crowded gathering that was in breach of the COVID rules and guidance was taking place in the press office vestibule. We accept, however, that it is possible, though unlikely, that there was nothing untoward occurring in the vestibule at the time he ascended to the flat. Gathering on 14th of January 2021. We note that some participants in the gathering received fixed penalty notices. As we have commented earlier, we do not consider that an event at this time was compliant with COVID rules if the purpose of the event was purely to maintain staff morale. Gatherings. Conclusions. We have set out and analysed evidence on 6 gatherings. This establishes that Mr. Johnson's personal knowledge should have led him, at least after due reflection and as gathering succeeded gathering, to question whether the COVID rules and guidance were being complied with. For several of the number 10 gatherings, as we have detailed, Mr. Johnson has argued that it did not occur to him that they were in breach of rules or guidance. This is despite the fact that he must have been aware of the number of people attending, of the absence of official work being done, and of the absence of social distancing without visible mitigations. In each case, he argues that he genuinely believed the events were covered by a work-related exemption to the rules. He also argues that efforts to socially distance and the putting in place of some mitigations where possible, albeit somewhere other than where the gatherings were taking place, were sufficient for compliance with the guidance. With regard to the rules, the gathering had to be essential or reasonably necessary for work purposes. A workplace thank you leaving drink, birthday celebration or motivational event is obviously neither essential or reasonably necessary. Mr. Johnson is adamant that he believed all of the events which he attended and of which he had direct knowledge were essential. That belief, which he continues to assert, has no reasonable basis in the rules or on the facts. A reasonable person looking at the events and the rules would not have had the belief Mr. Johnson professed. That is plain from the fact that around the UK during the period of pandemic restrictions, these events did not take place. The point is reinforced by the exposure of the mock Downing Street press conference video, which became public in December 2021. When asked about one of the gatherings we have examined, that of 18th of December 2020, and more generally whether the Prime Minister would condone having a Christmas party, Mr. Johnson's then Press Secretary, Allegra Stratton, was unable to think of any credible response and was evidently embarrassed. 5 of the 6 events we have focused on have the core purpose of thanking staff who had been working hard or raising morale following the departure of staff. Mr. Johnson, when asked whether he would condone gatherings for this purpose in other organisations, declined to say that he would, as we concluded. In view of Mr. Johnson's repeated exhortations to the public to follow the rules and guidance, indicating the importance he attached to their being taken seriously, we do not believe that, if asked at the time whether unsocially distanced leaving dues to maintain staff morale were permitted under the rules and guidance, he would have advised the British public that they were. In respect of the sixth event, the gathering to celebrate his birthday on 19th of June 2020, while we have no reason to think that the meeting that followed this event was anything other than a necessary work meeting, Mr. Johnson was unable to provide a convincing reason why this prior gathering was reasonably necessary for work purposes. With regard to the guidance, there was no obvious social distancing at any of the events for which the committee has photographs, and we have direct evidence about the lack of social distancing from witnesses. We have no evidence of substantive mitigations in place in the rooms or areas where the gatherings took place, save the 20th of May 2020 gathering in the garden because it was open air. The mitigations described by Mr. Johnson do not relate to the activities complained of. At best, they are such marginal expedients as not touching pens or passing things to each other, except, of course, alcohol. Mr. Johnson concedes that social distancing was not possible at these events, but maintains the guidance was complied with completely. That is not correct. Mr. Johnson refers to social distancing of less than 2 metres as imperfect social distancing. This term is not in the guidance. Without all possible effort being made to redesign the event to allow for social distancing of at least 1 metre with substantive mitigations is non-compliance. This inability to maintain full social distancing would have brought into operation a clause in the guidance relating to considering whether, in these circumstances, the event should take place at all. We conclude that Mr. Johnson's persistence in putting forward this unsustainable interpretation of the guidance is both disingenuous and a retrospective contrivance to mislead the House and this committee. We think it highly unlikely, on the balance of probabilities, that Mr. Johnson, in the light of his cumulative direct personal experience of these events and his familiarity with the rules and guidance as our most prominent public promoter, could have genuinely believed at the time of his statements to the House that the rules or guidance were being complied with. We think it is just as unlikely he could have continued to believe this at the time of his evidence to our committee. We conclude that when he told the House and this committee that the rules and guidance were being complied with, his own knowledge was such that he deliberately misled the House and this committee. What Mr. Johnson was told by others and what he told the House. The overall thrust of Mr. Johnson's evidence to the committee has been to downplay the significance and narrow the scope of the assertions he made to the House. He has argued that A. The assurances he referred to related only to one gathering, that on 18th of December 2020, and were correct in relation to that gathering. B. His assertions to the House relating to assurances about COVID compliance were only in respect of the rules, not the guidance. And C. When he referred 3 times to having repeatedly been assured about compliance, by repeatedly he meant on more than one occasion and by more than one person. The problem with Mr. Johnson's attempts to portray his assertions to the House as narrow in scope is that this interpretation is directly at odds with the overall impression members of the House, the media, and the public received at the time from Mr. Johnson's responses at PMQs. The message which Mr. Johnson clearly meant to convey was that rules and guidance at number 10 had been complied with at all times. Indeed, Mr. Johnson initially asserted that guidance had been complied with when he had meant to say rules, and rather than correcting what he now admits to have been an error, subsequently reiterated this assertion, despite having been advised by his principal private secretary not to make this claim. He was content to convey the impression that the events, plural, against which allegations had been made were in fact non-events, and to paraphrase, that it was nonsense to suggest that the rule makers at the heart of government were also rule breakers. The impression the House would have taken, and we conclude would have been intended to take, from Mr Johnson's repeated references to assurances, was that those assurances had been overarching and comprehensive, and to be given great weight. In fact, as we have seen, the only assurances that we can be certain were given to Mr Johnson were arrived at in haste, based on a press line to take, were not subject to investigation before either session of PMQs, and did not emanate from senior permanent civil servants or government lawyers, but from two media advisers, and were based only on their personal recollections. Although Mr Johnson claimed several times to have been given the assurances repeatedly in evidence to us, he scaled down that claim by arguing that by repeatedly he had meant on more than one occasion, so possibly only twice. Mr Johnson's attempt in his evidence to us to claim that his assertions at PMQs were narrow in scope amounts to ex post facto justification, and was clearly not the message he intended to convey at the time. As an ex post facto justification, it is false. Mr Johnson's failure to seek adequate assurances has also to be seen in the context of his direct personal experience of non-compliance with COVID rules and guidance at a series of gatherings which he attended or was aware of, as detailed earlier in this report. Misleading the House. Using the categories of misleading set out in paragraph 32 of the fourth report, we conclude that Mr Johnson misled the House when he said on 1st of December 2021 that all guidance was followed completely in number 10, when he said on 8th of December 2021 that the rules and guidance were followed at all times, on 12th of January 2022 when he said that events at number 10 were within the rules and guidance, and on 25th of May 2022 when he said that the rules and guidance had been followed at all times when he was present at gatherings to wish staff farewell. Mr Johnson misled the House when he failed to tell the House about his own knowledge of the gatherings where the rules or guidance had been broken. Mr Johnson misled the House when he said on 8th of December that he relied upon repeated assurances that the rules had not been broken. There is evidence that Mr Johnson was assured by two individuals who had worked at number 10 at the time that they did not think the gathering of 18th of December 2020 had broken COVID rules. However, we conclude that Mr Johnson had personal knowledge about gatherings which he should have disclosed. Mr Johnson concedes that there was no assurance about any gatherings compliance with the guidance that was in place at the time, as opposed to compliance with the COVID rules. Yet Mr Johnson gave the House the impression that those assurances had been overarching and comprehensive in respect of number 10's compliance with all COVID measures. The purported assurances were only about the gathering of 18th of December 2020, not more generally about number 10's compliance with the rules and guidance. Yet Mr Johnson gave the House the impression that those assurances had been overarching and comprehensive in respect of number 10's compliance with COVID measures across a whole period of restrictions. In particular, we have received no evidence that any specific assurance was provided in relation to the gatherings of 20th of May 2020, 19th of June 2020, 13th of November 2020, 27th of November 2020 and 14th of January 2021, which we have examined in detail. The context for the initial purported assurance was in response to a media inquiry, and the assertion that COVID rules were followed was initially developed in haste and without further investigation as a media line to take. They were therefore not appropriate for Mr Johnson to cite as an authoritative indication of number 10's compliance with COVID measures. The only two purported assurances for which there is firm evidence did not emanate from senior permanent civil servants or government lawyers, but from two media advisers, one of whom was a personal political appointment by Mr Johnson. The purported assurances consisted only of what those individuals themselves believed about the compliance of the gathering of 18th of December 2020 with the rules. They were therefore not appropriate to be cited as an authoritative indication of Number 10's compliance with COVID measures. Mr Johnson misled the House when he gave the impression that there needed to be an investigation by the second permanent secretary to establish whether the rules and guidance had been broken before he could answer questions to the House. While repeatedly making a statement to the House, he had personal knowledge that he did not reveal. We additionally find that Mr Johnson misled the House when he purported to correct the record on 25th of May 2022. We have concluded above that his statement on that day that the COVID rules and guidance were followed while he was in attendance at farewell gatherings Number 10 was misleading. As such, it represented a continuation of his previous misleading of the House, and seeking to present it as a correction was itself misleading. His insistence on the truthfulness of his statement in his written evidence, and his refusal to correct the record when invited to do so during his oral evidence on the 22nd of March 2023 is a further misleading. We further conclude that Mr Johnson has been disingenuous with the committee in ways which amount to misleading as follows. By adopting a narrow and restricted interpretation of the assertions he gave to the House in PMQs on 1st and 8th December 2021, which is at odds with the general impression he clearly wished to give in the House that all rules and guidance at Number 10 have been followed at all times. By claiming that when he referred to having been repeatedly assured, by repeatedly he had meant merely on more than one occasion. We note that as this is contrary to common English usage, it is clear that when Mr Johnson used the term repeatedly at PMQs, he wished his audience to suppose that there had been multiple occasions at which assurances had been given, rather than merely more than one, and as suggested by our evidence, possibly as few as two. By undertaking to provide a committee with the name of another person who had provided assurances, and in failing to do so. By stating at the oral evidence session that the committee had withheld from publication the evidence that I rely on which answers the charges, and a large number of extracts which I rely upon in my defence. But then the committee had facilitated the production of that evidence, accompanied by statements of truth, failing to make any use of it in a subsequent final submission. This strongly suggests that Mr Johnson did not rely on the evidence at all, but was simply using it as a gambit to criticise the committee in the public hearing. By advancing an unsustainable interpretation of guidance in order that he can deny the implications of the evidence, showing a lack of social distancing. By being unable to deny that he said the words, probably the most unsocially distanced gathering in the UK right now, while not admitting that he said them, which has a ring of avoidance about it. Was it a contempt? We have given very careful consideration to the question of whether Mr Johnson misled the House recklessly or intentionally. He himself told us that, "I am here to say to you, hand on heart, that I did not lie to the House. When those statements were made, they were made in good faith and on the basis of what I honestly knew and believed at the time." Mr Johnson argues that whether or not the COVID rules and guidance were breached at gatherings he attended or was aware of at Number 10, and he continues to maintain the case of 6 gatherings we investigated that they were not breached, he himself, along with many others at Number 10, genuinely believed they were complying with the rules and guidance. To a great extent, this defence depends on whether Mr Johnson genuinely believed the gatherings were work events that satisfied the criteria in the rules that such events be essential for work purposes, reasonably necessary for work purposes, and the criteria in the guidance that if social distancing cannot be observed, such an event needs to continue for the business or organisation to operate. We have noted that Mr Johnson was not willing to say that. If asked, he would have advised the general public that work events intended solely to raise morale satisfied these criteria. We have set out at paragraph 117 our conclusion that it is unlikely on the balance of probabilities that Mr Johnson, in the light of his cumulative direct personal experience of these events, could have genuinely believed that the rules or guidance were being complied with. We have also set out a list of ways in which we consider Mr. Johnson has misled the House or been disingenuous in his responses to our inquiry. His personal knowledge of breaches of the rules and guidance, combined with his repeated failures proactively to investigate and seek authoritative assurances as to compliance issues, amount to a deliberate closing of his mind or at least reckless behaviour. We find it highly unlikely that Mr. Johnson, having given any reflection to these matters, could himself have believed the assertions he made to the House at the time when he was making them, still less that he could continue to believe them to this day. Someone who is so repeatedly reckless and continues to deny that which is patent is a person whose conduct is sufficient to demonstrate intent. Many aspects of Mr. Johnson's defence are not credible. Taken together, they form sufficient basis for a conclusion that he intended to mislead. We conclude that in deliberately misleading the House, Mr. Johnson committed a serious contempt. Recommended sanction. We have concluded above that in deliberately misleading the House, Mr. Johnson committed a serious contempt. The contempt was all the more serious because it was committed by the Prime Minister, the most senior member of the government. There is no precedent for a Prime Minister having been found to have deliberately misled the House. He misled the House on an issue of the greatest importance to the House and to the public, and did so repeatedly. He declined our invitation to reconsider his assertions that what he said to the House was truthful. His defence of the allegation that he misled was an ex post facto justification and no more than an artifice. He misled the committee in the presentation of his evidence. Having taken into account the factors set out above, we considered what sanction would be appropriate in this case. We unanimously concluded that the minimum sanction we should recommend to the House should be suspension from the service of the House, sufficient to engage the provision of the Recall of MPs Act. In agreeing to recommend that sanction, we took into account that this case will set a precedent for the standards of accountability and honesty that the House expects of ministers. We have no doubt that Parliament and the public expect the bar to be set high and for there to be serious consequences if a minister, as in this case, impedes or obstructs the functioning of the House by deliberately misleading it. Having reached this provisional conclusion as to the recommended sanction, we then followed the procedure we had set out in our procedure resolution and communicated to Mr. Johnson the committee's proposal to recommend a sanction of suspension for a period long enough to engage the provisions of Recall of MPs Act, inviting his comments. This material was sent to Mr. Johnson under conditions of strict confidentiality. We set out the events that followed and our view of their implications for sanctioning Mr. Johnson in the next section of this report. Mr. Johnson's resignation as an MP and his attack upon the committee. We note that Mr. Johnson does not merely criticise the fairness of the committee's procedures, he also attacks in very strong, indeed vitriolic terms, the integrity, honesty and honour of its members. He stated that the committee had forced him out anti-democratically. This attack on a committee carrying out its remit from the democratically elected House itself amounts to an attack on our democratic institutions. We consider that these statements are completely unacceptable. In our view, this conduct, together with the egregious breach of confidentiality, is a serious further contempt. Notwithstanding his protestations of respect for the committee and his earlier deprecation of language, such as kangaroo courts and witch hunts, we note that in a statement of 9th of June, Mr. Johnson himself used precisely those abusive terms to describe the committee. This leaves us in no doubt that he was insincere in his attempts to distance himself from the campaign of abuse and intimidation of committee members. This, in our view, constitutes a further significant contempt. On 12th of June 2023 at 11:57 p.m, Mr. Johnson's lawyers delivered to the committee a further purported response to our warning letter of 8th of June. We have considered its contents, even though we are not obliged to do so. The response was not accompanied by a statement of truth from Mr. Johnson. The response makes a series of tendentious accusations. The document is reproduced in full at Annex 3, together with our comments in each paragraph. Before his latest purported submission, we had decided to treat Mr. Johnson's public statement made on 9th of June in response to our warning letter as his response to that letter and his last submissions to this inquiry. We note that on 9th of June, Mr Johnson stated that it is in no one's interest that the process the committee has launched should continue for a single day further. We agree with Mr Johnson's view on that point. Contrary to Mr Johnson's assertions, he has been given multiple opportunities to set out his views and to comment on the evidence in the inquiry. We set out in detail the evidence and the issues to be raised with him in our fourth report, published on 3rd March 2023. We disclosed to Mr Johnson in unredacted form all the evidence we proposed to rely upon and the identity of all of our witnesses. At the start of the inquiry in July 2022, Mr Johnson was invited to make an initial submission in writing concerning the allegations and to identify any witnesses that he believed could give relevant evidence. He did not make such a submission or identify any witnesses. Mr Johnson was invited to give oral evidence and publish a written statement, which he did, and was questioned about the evidence and the issues raised in the fourth report. Mr Johnson was invited to make final submissions in the inquiry and did so. Mr Johnson was sent details of our proposed criticisms of him and the evidence supporting them on 8th of June 2022 and invited to respond. None of the evidence which we relied on in the material sent to Mr Johnson on the 8th of June was new to Mr Johnson. It was the same as that which was put to him in the fourth report and in the oral evidence session. He had the opportunity to respond to that in oral evidence and by written submission, and he did. In his oral evidence, Mr Johnson accused the committee of suppressing evidence which would be helpful to him. We invited him to identify any such evidence. The committee obtained that evidence from the witnesses he had indicated, supported by statement of truth. In the event he placed no reliance on it. The clear implication is that there was nothing in the evidence, and his criticism in public was a cynical attempt to manipulate member and public opinion. Our final conclusion is in relation to sanction. Although Mr Johnson's resignation as an MP renders it impossible for a sanction of suspension to be imposed, we draw attention to the fact that before the events of Friday 9th of June, we had provisionally agreed to recommend a suspension long enough to engage a provision of the Recall of MPs Act. In the light of Mr Johnson's further contempts, we put on record that if he had not resigned his seat, we would have recommended that he be suspended from the service of the House for 90 days for repeated contempts and for seeking to undermine the parliamentary process by deliberately misleading the House, deliberately misleading the committee, breaching confidence, impugning the committee and thereby undermining the democratic process of the House, being complicit in the campaign of abuse and attempted intimidation of the committee. In view of the fact that Mr Johnson is no longer a member, we recommend that he should not be granted a former member's pass. That's some sorry shit. I hope this has been of use to some people. If you'd like to give me a few dollars, a few pounds, a few euros, check out my Patreon, where it is patreon.com/Andy Luke, Luke. I publish monthly short stories, poetry, videos, fiction, comedy, and that's at patreon.com/Andy Luke. Please feel free to share this around, cut bits of it up for your own use if you want. Produce, obviously, I prefer Andy Luke as author to be recognised, but I realise this isn't always possible. As long as you don't share the whole thing without accreditation. Thank you.